Good afternoon and welcome to the Senate Judiciary Committee public hearings dated January 18th, 2022. We're going to start the day by opening the public hearing on Senate Bill 300 and recognize the prime sponsor, Senator Avard. Good afternoon, Senator.
Good afternoon, Madam Chair, committee members. For the record, I'm Senator Kevin Avard from District 12, and I am the prime sponsor of Senate Bill 300FN. I had received, just this year alone, just so many requests to put in bills, and with regards to this topic. And I lost count of all the people that that really wanted me to put in something. And so this bill basically defines and includes it includes the refusal of any experimental drug and the protection provided under the Commissions for Human Rights. It's a civil right, and it has to do specifically with experimental drugs. If you go out throughout the entire bill, you'll see where a refusal to accept, ingest, or otherwise participate in the use of experimental drugs. And the reason is because people are worried about being discriminated against, whether they're being forced to take a drug against their conscience or for whatever reason, but under the idea that it's experimental. They don't know what the outcome is. They don't know what the medical long-term repercussions are for taking these drugs are, and so we just wanted to put it in the human rights commissions that people cannot be discriminated for refusal of such experimental drugs. That's it.
That's it. Thank you very much. Thank you very much for your testimony, Senator. Are there any questions from the committee? Senator Gannon.
Thank you for taking my question, Senator. So we'll just say, for instance, I know you're not specifically talking about COVID or anything, but let's say I was. So would you say, are you considering the 2 vaccines and the booster that are now available still experimental?
I'm not considering anything experimental. This is just general. Anything that is experimental. I don't know if they're experimental or not.
Thank you.
Are there any further questions? Senator Khan.
I'm going to just quick follow-up. I'm sorry, Madam Chair.
Okay.
The legislation we passed last year that left exemptions, at the time I don't think the 2 first shots were immune, but we said we carved out because we were very concerned about nursing homes and hospitals. So you would have then at that time, if they weren't fully authorized, you would have said we couldn't say that nursing homes and hospitals could mandate, right? Back at that time when they were experimental, you would have said a hospital could not mandate the COVID medication at that time before it was CDC approved.
This particular bill is from this point on now.
Okay.
Anything experimental, you cannot be discriminated against.
Okay, thank you.
Are there any further questions from the committee? Okay, seeing none. Oh,
No,
Senator
I'm sorry.
Khan.
No. All right, the experimental drug, I'm going to follow up. I have a different question too, Madam Chair, but follow up on this experimental drug. Where did the definition come from?
Definition for what, Senator?
Experimental drug.
The thin air. Anything that is experimental, that has not been approved by the CDC or FDA, if it has not been approved and it is still in the experimental stage, to force somebody and discriminate one way or another, whether they've taken it or not, or have to be to prove that you've taken it or you haven't taken it, this would eliminate that.
Yeah. I think you've just added to the definition that's provided in the bill. Just a point.
Well, if it's in the bill, then that's where your definition is from.
Right.
I'm not sure why we would ask that, but. if it's
Well,
in the bill.
because there's no reference to a federal guidance, state authority, any concoction. So I don't understand the definition.
Well, I'm not going to try to complicate it any more than that it is. It's supposedly very simple. Any type of drug that is experimental and it's an experimental stage, one should not be forced to take it.
Yeah. I'll leave it to one more
Yes, follow up.
question. So the other point, if I'm an employer, is it the intent, if I'm an employer and I or my existing staff, I know that they are immunocompromised and I know that there is an outbreak of COVID and there is a means of preventing the spread in my workplace, does this say that I would be violating civil rights by not hiring or making it a condition of employment to require that somebody had taken some preventive treatment?
This specifically has to do with experimental drug, Senator. Are you saying that the COVID vaccination is experimental?
They were at a point.
But as I had mentioned to the other senator, from this point on.
Yeah, and that's where the definition would help me. But the, okay, I guess I buy that. I wonder how this is going to affect an employer who, a private sector employer, could be limited staff, could be immunocompromised, could face another variation on a COVID virus, and how they might be accused of discrimination because of having placed a requirement as a condition of future employment.
Are there any further questions?
Just a
Senator Gannon?
quick- So I believe, which will help Senator Khan, experimental drug to you means what any layman would read it to mean, not medically accepted in the medical community, something like that.
Yeah.
So I'm happy with your definition. Thank you.
Thank you.
Are there any further questions from the committee? Okay, seeing none, thank you very much for your
Thank you, Madam
testimony,
Chair. Thank you,
Senator.
committee members. Be nice to me.
Next, we're going to call Paula Minahan. Okay. Good afternoon, Ms. Minahan.
Good afternoon, Madam Chair, members of the committee. Ran outside to feed my meter and my nose is running, sorry about that. Good afternoon, Madam Chair, members of the committee. For the record, my name is Paula Minahan, Senior Vice President, State Government Relations for the New Hampshire Hospital Association, representing all our hospitals, as well as community hospitals, as well as specialty hospitals. We have concerns with Senate Bill 300. The bill before you defines experimental drug and includes the refusal of an experimental drug and the protections provided under the State Commission on Human Rights. In our review, it appears to do two things. One, define experimental drug to apply to COVID-19 vaccinations, and two, apply the protections afforded under the State Commission on Human Rights for anyone that is presumably required as a condition of employment or in order to access services but refuses. To the first point, COVID-19 vaccines are not considered experimental. COVID-19 vaccines are under the authority of the Food and Drug Administration and fall under either emergency use authorization or full authorization. This does not make them experimental. In fact, COVID-19 vaccines have gone through initial developmental stage, clinical trials, authorization or approvals, manufacturing and distribution processes, and safe safety tracking. I did attach a document from the CDC that I think explains it in much more detail. I will just leave that with you for your review. Secondly, the bill, if passed, we believe has a chilling effect on entities, employers, and other businesses and venues from being allowed to impose policies that they determine are in the best interest of their employees and patrons and be unfairly subject to the oversight of the State Commission on Human Rights. Vaccinations have been subject to this oversight, have never been subject, to this oversight, and it is inappropriate to assert that vaccinations create a human rights violation. We believe it's important to note that employers that do require vaccines are, as a condition of employment, also allow for exceptions for both medical and religious reasons. They have written policies that outline the process for these employees, and there is a comprehensive review process that is followed. And all employees should be allowed to make make vaccinations of any kind a requirement of employment if they so choose. And thank you for the opportunity to comment on Senate Bill 300.
Thank you very much, Ms. Minahan. Are there any questions from the committee? Senator Gannon and then Senator French.
Thank you, Madam Chair. So Senator Vide was pretty clear that he wasn't trying to be specific with the past COVID vaccine. But at what point would you have said that an employer could have, along the way in the last 2 years, at what point could they have said you have to take the first, when it was CDC approved, the first vaccine, the second vaccine, the booster? At what point, when it was CDC approved? Is that when you'd say you could tell us we had to? And before that?
So, again, I think it's confusing to equate experimental with emergency use authorization, just very different. So the COVID vaccine, the 3 vaccines that have been approved went through EUA, and then the manufacturer applies to the FDA to get full authorization. So that's that whole process. But there will be other vaccines, I believe, that will be going through that same process. Again, they're not considered experimental. That is, our position is that they were never experimental. They were emergency use authorization. And as my testimony indicated, that they went through rigorous review, trials, et cetera. So as far as when it would be okay, or for an employer to require it, so all I can speak to is what our hospital's experience was, and they waited until August of this last year to start requiring vaccines as a condition of employment. It started, I think, early August, and I believe they were going through the manufacturers were going through their final review at the FDA at that point for full authorization.
Quick follow-up?
Yes, please.
So now there's a 4th vaccine in the pipeline, the Israeli one, and which they're talking about may or may not in the near future become. So it would be at the point when the CDC gives it that first emergency use, that would be when you'd say a hospital could say you have to mandate? Come out with their internal mandate?
I would need to check with the hospitals as far, and their infectious disease
thank you.
specialist to answer that question. Sorry, I can follow up though.
That's okay, thanks.
Thank you. Senator French had a question?
Thank you, Madam Chair. And thanks, Paula. Good to see you.
Nice to see you, Senator.
So, is your testimony that New Hampshire Hospital Association believes people should be subjected to getting experimental drugs in order to have employment?
Our position is that again, as my testimony stated, it is, I'm concerned that experimental drugs are being associated with, experimental drug, the definition is applied to COVID-19, and that's my testimony that it was not. And then I also question, and I am not a human rights lawyer by any means, but I believe the commission is, ED is here, and I would hope that she could speak. But I question this being included in the State Commission on Human Rights as a protected class, I guess it would be. And I question that, if that's appropriate.
Follow up?
Thank you. So, the senator said this was not directly at COVID-19. It was for experimental drugs. Would you have a problem with that language? I mean, experimental drugs not pertaining to COVID-19?
I think I heard Senator Khan's question. I do question the origin of that definition. I don't know that I heard the answer. I was in the back and I couldn't really hear what Senator Avard said. I don't know where that definition comes from. I don't know if he stated. I'm just curious because I think it's important to understand where that definition comes from.
Okay, great, thanks, Paul.
You're welcome.
Are there any further questions from the committee? Senator Khan?
Thank you, Madam Chair. Experimental versus conditional
Emergency use authorization.
emergency use authorization. Are you concerned that emergency use authorization is considered by some people to mean that it's an experimental drug?
I am concerned about that, and as my testimony indicated, that's what I am wondering if it's applying to COVID-19, and that's why, on the record, I wanted to state that COVID-19 vaccines were not considered experimental, and that's why I provided you with the CDC information about what they went through for emergency use authorization, which I believe is what a lot of vaccines go through.
Thanks for that clarification.
You're welcome.
I believe I'm still getting emails that call COVID-19 emergency use as an experimental drug that people refuse to take. I assume you're hearing the same thing.
As my testimony stated, that's why I wanted to be on the record.
Thank you.
Yes, you're welcome.
Thank you. Are there any further questions? Okay, seeing none,
Thank
thank
you.
you, Ms. Minahan.
Thank you.
Next, we're going to call Sean Thomas.
Thank you, Madam Chair, members of the committee. My name is Sean Thomas with the Mers and Praesol. We represent the New Hampshire Nurses Association. Thank you for this opportunity and time to testify. I'm sorry, I also brought with me hard copies of written testimony prepared by the association. This was also emailed last night. It should have come from the association's executive director, Pam DiNapoli. I won't read it, but instead try to summarize it quickly. The New Hampshire Nurses Association is opposed to Senate Bill 300. I know the committee has discussed, and there seems to be some question about the definition of experimental drug. But the immediate intent of Senate Bill 300 seems to be to get at the COVID-19 vaccine, trying to label it as an experimental drug. The COVID-19 vaccine is not an experimental drug. Instead, it is approved, recommended. It has been proven to be safe and effective, and it is the best tool we have to end the pandemic. The Nurses Association is opposed to Senate Bill 300 because it would hamstring businesses, including hospitals, long-term care, and other healthcare facilities, in terms of choosing how to best protect the health and safety of their employees, customers, and patients. The workplace is a common setting for COVID-19 transmission, and this mandate in Senate Bill 300 against requiring COVID-19 vaccines takes away a tool available to businesses that may be used to keep their workplaces safe, open, and their employees healthy. In healthcare settings, it is important to keep our nurses and other healthcare heroes safe and at work and doing what they do best, caring for and protecting patients. The New Hampshire Nurses Association urges you to recommend ITL on Senate Bill 300. Thank you again for your time.
Thank you very much for your testimony. Are there any questions from the committee? Okay. Seeing none, thank you very much.
Thank you.
Next, we're going to call Netch Gray.
Madam Chair, Nate Grace for the New Hampshire Municipal Association. I did submit written testimony via email yesterday. Hopefully you've had a chance to see that. As has been mentioned by the committee, we were also a bit confused about the definition of experimental drug. What we came up with was, after focusing on the language legal immunity from any adverse effects, is that it probably meant any medical countermeasure that is ingested or inserted into humans and covered by the Federal Public Readiness and Emergency Preparedness Act, or PrEP Act declaration. That would, my understanding at this time, include a variety of drugs to combat COVID-19, including vaccines, but could include any number of other items related to future pandemics. Essentially, that act functions to allow the U.S. government to ramp up the production of any medical countermeasures that can be used to thwart pandemics. That's our understanding, and our concern would be, if that is in fact the case, that you'd have an arbitrary distinction where you might have some approved drug or vaccination, since that's what we're focusing on, that could be required by an employer. Then the federal government makes this declaration under the act, and that would result in this bill, if it were passed, coming into effect, and therefore the employer no longer being able to require that, and then subsequently, once that declaration expires, could re-require that, and that's going to create a lot of confusion. That's our understanding of how this definition would function.
Thank you very much for your testimony. Are there questions from the committee? Okay, seeing none, thank you very much.
Thank you.
Next, we're going to go to Julie Smith.
Thank you, committee members. Julie Smith from Nashua, in favor. I had stuff written to say, but with all this talk of people before me talking about the whole institution of experimental, I thought I'd say a few things thoughts that I had just now. I'd like to go on record as a private citizen that my personal opinion of experimental is the absence of sufficient longitudinal data, that being what happens over time. Experimental. A lot of life insurance companies tend to not pay out when someone takes something experimental. And quite frankly, FDA approval to me means that a deal has been made. Emergency use doesn't matter. And a fellow constituent of the sponsor, who is unable to be here today, wrote some words that I totally agree with, so that's what I'm about to share. Human rights are not country specific. The principle is such that human rights are the right to life with dignity. It is most troubling that we have come to in this society. This is something we must legislate. I am in support of SB 300 because it is necessary to secure the human right to refuse experimental drugs and treatments, to continue the freedom from discrimination, right to life, equality before the law, liberty and personal security, education, freedom of thought, and free movement. It cannot be understated that human rights are vital for the existence and development of individuals. Human rights create a better environment, better living conditions for people, and preserve their dignity. Passing this bill will create a standard of human rights law with a standard for what is a human right. Governments can be held accountable for their actions. There is power in naming an injustice and pointing to a precedent, which is why this bill is so important. The people of New Hampshire must have something tangible to point to. This bill will allow protection under human rights to give people the right to choose how they want to live. For the critics of this bill does not seek to take anything from anyone. It simply and rightly allows for individuals to make their own health and medical decisions as they see fit, and in turn be allowed to live in the society of which they were born, free from the inability to participate in basic civil, political, economic, social, and cultural rights due to a medical or personal refusal of any experimental drugs or treatments. As of late, We are constantly reminded that our democracy is at stake. This bill sounds a lot like a protection of our democracy, which we are told accommodates the diversity of opinions and people. So it would seem to have a lot to do with human rights. This is the live free or die state, so I ask that you do right by our state motto, its residents, and vote yes to support the passage of SB 300. And I also like to add that I find it disgusting the number of lobbyists here that are opposed to it. This is not about business. This is about human rights. And thank you for the time.
You're welcome. Would you be willing to answer questions if someone has one? Okay, are there any questions? Senator Gannon.
I never know when to be quiet, but I appreciate your liberty interest, and I would almost always be for them. My problem is that I feel that you're not looking at, say I have a small business, 5 people. We don't deal with the public, we buy and sell stocks or something. You're gonna tell me that I have to let that person into my establishment when I fear that I have an immunocompromised wife. I'm diabetic, I'm probably immuno. So I fear that I know you have an interest, a liberty interest, but isn't it clashing with like a hospital who wants to, or a nursing home, they want to be sure that no one has COVID to spread. And if we can't believe the government and the CDC when they say a drug is safe, I fear that you're going to trample on like a business interest or hospitals. I'm curious what you think of that.
I don't think it's trampling on a business or a hospital. It's about the refusal of something experimental, and everybody's using the word COVID, and I get it. It is a current event, and it's a buzz topic right now. But this is about the precedent and future experimental treatments and drugs also.
Thank you for taking my question. Thanks.
Are there any further questions? Senator Khan.
Thank you, Madam Chair. You'd be disappointed if I didn't ask you a question, maybe. I asked everybody else. I'm wondering, if you felt that the requirement to take a COVID vaccination was being asked of you, do you think that this act here would give you cause to object and file suit?
Meaning if this law passed and I was asked to in order to obtain employment or do business with a business?
Thank you for rephrasing that.
Is that what you mean?
Yes.
I would say so, yes.
Thank you.
Okay, are there any further questions for Ms. Smith? Okay, seeing none. Thank you very much for your testimony. Next is Russin Chester.
Thank you, Madam Chair and Senators. It's Roseanne, but
Roseanne,
you were
okay.
very close. I'm coming to here today as a citizen. My plan was not to speak. I thought it was a pretty clear-cut bill. It's a human rights issue. I've spent over 30 years of my life in being a human rights activist but on the front lines. So working with people that have human rights violations. And I see them all the time. And this bill would help prevent that. I, too, was appalled with the fact that the only opposition to this bill seems to be businesses and financially motivated. And that hurts my heart so tremendously. I was born and brought up in this state. I considered the state of New Hampshire the most for the people state in our union. And being here and going to these committee meetings and listening to how this situation has been so politicized and has made everything partisan and everything is us or them, that's not what we're about. That's not what this bill is about. This bill is about the human right and dignity for humans business rights, yeah, they have rights, but human rights should be before businesses in all instances. So that being said, because I've heard every single professional entity that opposes this bill come up and talk about COVID-19, that wasn't my plan. That wasn't my intent. But I am going to use this platform now to talk a little bit about it. What we know today about COVID-19 is even the vaccinated spreads COVID-19. We know that small businesses are being encouraged to let COVID-19 positive people come back to work. Given what we know now, this really is a moot point with regards to, is it safe and effective? It doesn't matter about what happened in 2020 or even 2021. We have to make a difference for the future. I saw in 2020 and I saw in 2021 hundreds of thousands of people being discriminated against in our United States and across the globe for their beliefs. They should never be discriminated for their beliefs. That is completely unacceptable. It is a human right to have your own personal beliefs. And the fact that we're actually arguing about, well, yes, it's a human right, but it's bad for business, is disgusting. Thank you, and I'm more than open. I'm sorry about the passion, but I'm more than open to take any questions.
Thank you very much for your testimony, and there's no need for you to apologize whatsoever. Are there any questions from the committee? Senator Gannon.
So I don't see it exactly the same as you. I appreciate your position. So we're at my little fictitious company of 5 people. 5 real people. It could be me, Senator French, Senator Carson, and say we're all immunocompromised except for the one 25-year-old who's very healthy and he's not concerned at all. I own the shop and I'm very concerned about my health. The other 4 are families. And to me, it's a real concern. So don't I have a human right not to be exposed to something I consider dangerous?
So we're talking specifically regards to COVID, not this bill, correct?
Sure.
Okay. With regards to COVID, again, what we know now is, or what we have been told by the CDC, WHO, and a lot of the other people is that if you're vaccinated, you will have the likelihood that you're going to have a less severe reaction is wonderful. If you're not vaccinated and you're immune compromised, then you may have a hard time of it. If you're not vaccinated and you're not immune compromised, you may or may not have a hard time. All of those situations, both the vaccinated, the unvaccinated, and the immune compromised that can't be vaccinated, all have the propensity to spread the virus. So what's the point of that type of a situation, knowing what we know now? Now, again, what I'm looking at is this bill is not about COVID-19. It's about experimental procedures and drugs that we're allowing businesses to mandate against a New Hampshire citizen. That's my issue. Thank you.
Quick follow-up.
Yep.
Follow-up?
So do you think that we need to tighten up the word experimental to something that medically accepted? Do you think maybe there would be a little tightening in his definition, his one sentence?
The only problem that I've seen is in a lot of the bills that I've seen coming before our legislatures right now is that when we say medically accepted, that becomes very confrontational too in this arena, because there's these medical people that say this and those medical people that say that. I think experimental is actually a good term because it's a much clearer, much more black and white definition. And in the situation going forward in 2022 or 2025, when a situation happens and we have an emergency order or an emergency use situation, then we can deal with it, is the way I look at it.
Thank you.
Senator French, you had a question?
Yes, thank you, Madam Chair. And thank you for testifying today. I was just curious, I don't know if this is in your wheelhouse or not, but do you think that this type of legislation would actually help businesses and give them cover? And I ask that because, say the feds decide that they're only going to give loans and bailout money to companies that demand their employees get vaccinations or use experimental drugs. Do you think this would then give those companies a pushback on the feds for such a mandate?
I do think that it would be advantageous for the companies who would not be able to get loans or funding. And on the other side, it would force transparency to the ones that are taking federal monies for these experimental and/or emergency use products. So I think that it's actually, I appreciate the question, because personally, I think that it would, if anything, shed some light and some clarity on, and transparency on not only what's happened in 2020 and 2021, but going forward, businesses would be able to have the teeth to say, well, you know, I have the right to take the federal money just as much as anyone else.
Great, thank you.
Are there any further questions? Okay, seeing none, thank you very much for your testimony.
Thank you.
I do have one person who signed up, Ms. Ani Malachi. If you didn't say you wanted to speak, but would you like to come forward? Okay, I thought you might want to, that's why I kind of held you to last, because you've heard the discussion.
Thank you. Thank you, Madam Chair. Good afternoon, everyone. My name is Ani Malachi. I'm the Executive Director of the Human Rights Commission, which is where, if this legislation passes, would put the enforcement authority in RSA 354-A, which is the statute by which the Commission enforces the non-discriminatory or the New Hampshire laws against discrimination. The commission doesn't necessarily have a side on this, for or against. I'm certainly here to answer any questions that you might have. And I apologize, I had a meeting before I came into this one, so forgive me if I end up reading a little bit of information. But there are some other states in New England that have differing pieces of legislation. Some are who have made protected classes out of people who are not receiving vaccines. So, and I can certainly forward that information. I won't bore you with trying to read all of it. I can certainly forward that to you. The big thing here is that, yes, this would create an additional protected class. What happens with that is obviously within the purview of this amazing committee and the rest of the lawmaking body as to whether or not that is something that you would want to do. In my fiscal note, I stated that it would be difficult for me to ascertain if we would have a large number of cases, no cases, a lot of inquiries. I wouldn't be able to judge that at this point. We have had potentially one charge moving forward, and that's sort of where we are right now. But as you well know, as laws are made or changed, then it provides opportunities for people to do what they feel is necessary. And I'm sure you're currently aware that if you have a religious exemption or a medical exemption, you can certainly not do a required vaccination potentially, but certainly that business owners have a right to create the standards for their businesses. And I will forward to you the information on the surrounding states. New Hampshire is its own wonderful place. We do live in New England, and this information that I'll send to you is not at all to say that we should do what other states are doing. It's just to send you information on this particular topic that is taking place right now. So at this point, I think that is all that I have to say, but I'm open for any questions you might have.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
Are there any other member of the public who would like to speak to Senate Bill 300? Okay, Okay, seeing none, we'll close the public hearing. There we go, thank you. Speaking no, 1, 2, 3. Just let me know when you're ready to go. You're all set, Jenny? Okay. We're going to go ahead and open the public hearing on Senate Bill 296 and recognize our own Senator French to introduce the legislation.
Thank you, Madam Chair. And good afternoon to the entire committee. For the record, my name is Harold French, Senator from District 7, and today I'm here to introduce to you Senate Bill 296, which is a recycled bill. For those of you who were here a term ago, it was formerly 509, and when presented by my Democrat colleagues, I thought it was terrible and voted against it. But I put in the same bill this time thinking it's wonderful. So Senate Bill 296 is a bill about fairness. It amends RSA 354A, so the complainant is the only entity that can remove a discrimination claim to court from the Human Rights Commission. Under current law, one's employer can force an employee to court after a finding of probable cause of discrimination has been made by the Human Rights Commission. This makes the employee have to start the process over again from scratch. The employee should be the only person to decide where to pursue their claim. This bill would not impact many claims, but for those it does, the impact would be invaluable. I have several people behind me that will be taking you right through the weeds and the meanings of this bill.
Thank you very much, Senator, for your testimony this afternoon. Are there any questions from the committee? Senator Khan.
Thank you, Madam Chair. Senator, you could save me the lookup. I was remembering this bill, and so you've clarified it was Senate Bill 509. I assume it was in 2020 that
Right.
this was. Was this just dropped because of the COVID, or
I don't know why it fell through.
Session? Or?
I don't know why it fell through, probably because I was against it at the time, but I've become more liberal in my older years and have gone for it now.
I'll look it up.
Okay, look it up.
Thank you.
Thank you.
We'll be happy to supply the committee members with a copy of Senate Bill 509. Ms. Horgan can take care of that for us.
Docket.
Okay, okay, next we are going to go to Megan Douglas. There's two of you to come up together? Oh, okay.
It's the docket that I want.
It got vacated, so yeah, so it was just a COVID victim.
Thank you, Madam Chair, and members of the committee. Thank you for the opportunity to speak in support of SB 296 today. For the record, my name is Megan Douglas. I'm an attorney here in Concord. I work at the law firm of Douglas, Leonard, and Garvey. I've been a practicing employment law attorney for about 12 years. I represent almost exclusively plaintiffs, and I'm very familiar with the problems that plaintiffs face at the end or nearing the end of the Human Rights Commission process. And I'd like to talk today specifically about the problems that pro se plaintiffs face. The best way that I can explain it is by analogy. Imagine if you're playing a fairly complicated board game, and you're drawing cards and you're rolling dice and you're moving square by square along the board, And of course, you have an opponent, right, who's doing the same. And you get to the very end of the game board, not the very end, but near to the end, and all of a sudden your opponent says, flip, you know what? I don't want to play this game anymore. It looks like you're winning, and I want to play the game somewhere else. And that other game is not, say, Candyland or Chutes and Ladders. It's Monopoly, which is going to take a real long time, and you're going to need help playing it. What happens to too many pro se plaintiffs, members of the committee, is that at that point, though they have probable cause to suggest that they have good discrimination and retaliation claims, they give up. To put some real life, to put a real life example to my board game analogy, let's say we have a pro se plaintiff named Jason. Jason's story, by the way, is detailed in this chart. Jason works in a factory. He has devout religious beliefs. He wears dress consistent with his religious beliefs. He's harassed by his coworkers because of these beliefs and because of his dress. He reports this harassment to his supervisor, and the supervisor, rather than correcting the harassment, is irritated by the fact of the complaint that he has to deal with and puts Jason down by giving him a humiliating, demeaning job task to do that nobody else wants to do, to put him in his place. Now, Jason hasn't lost his job yet, so there's not wage loss from which a plaintiff's contingency fee attorney can help, with which a plaintiff's attorney can use to support representation and to help the employee. All he really has right now is the emotional harm, the offense, and the intolerable workplace that he has to go to day in and day out. So he can't get an attorney to help him. He goes to the Human Rights Commission and he tells his story to an intake person at the commission. The commission takes down a skeletal complaint. An investigator is assigned. The investigation proceeds for several years sometimes, involving submission of paperwork, submission of text, submission of emails, interview of Jason and the supervisor and the coworkers and the president of the company. And the investigator at the end has to make a decision, which is whether, based on this information collected, a reasonable fact finder sitting on the commission, one of the 7 members, could determine that Jason was discriminated against or retaliated against by the supervisor. If the investigator decides that the answer to that question is no, Jason's done. Jason is done under state law, under RSA 354A. The only thing Jason can do is appeal to Superior Court, which is very arduous and almost never attempted. Okay? If probable cause is the decision, if the answer to the investigator's question is yes, the investigator will issue probable cause, and it's at that point when the employee should have the right to go to mediation and then a hearing if the mediation fails before the commission. But what is happening all too often for pro se plaintiffs is employers are saying, nope, it looks like you're getting too close to the end of the game and you might win, so I'm going to take you to court. And that starts another 2-year process and litigation all over again for Jason. And Jason very, often gives up. And the workplace stays the same. And that's not what we intended with RSA 354A. And I will take any questions that you might have.
Thank you very much for your testimony this afternoon. I have any questions?
I'd just like to comment that Attorney Douglas is very good at what she does. Everyone agrees that she does a very good job at what she does.
Thank you, counsel.
Are there any further questions from the committee? Senator Gannon?
So we got to the point where the employer might say, yeah, you have done something wrong, we want to cure it, and now you're not going to let them cure it because you want to take it all the way to the Supreme Court. You're not letting them cure, not the Supreme Court, but you're not letting them cure the problem at a mid-stage. You're assuming that they're not really going to solve the problem. You're assuming they're just doing this to wear down the other party. So I'm seeing.
Oh, I see.
The employer might be genuinely, geez, I now realize we're doing something wrong. We have to make sure that this employee isn't harassed by his fellow workers. We're going to talk to the supervisor and say, give them counsel and you can handle this, right? We're going to rectify the situation. Are you stopping what could end right there and take care of the problem?
Well, that would be wonderful if the employer would concede its own workplace problems. Typically, that happens at conciliation at the commission, which is after the probable cause finding. But what we're seeing happening instead is we suspect employers are using their knowledge of the fact that the employee has to start all over again, outgunned, unsupported at Superior Court. So therefore, we don't really have to do the work of making our workplace right. Instead, we can just threaten to take the plaintiff to court and we're done. We don't have, I'm not sure I entirely understand your question. I think it's great if employers decide to fix their problems at any stage in the process. Okay.
Are there any further questions from the committee? Senator Khan?
Thank you, Madam Chair. I think I agree with you on this is an unfair step that the employer could take. Would but say this is defeated, this doesn't go forward for some reason, does it mean that, I mean, the employee could take the findings from the Human Rights Commission and use those findings as evidence in whatever case proceeds, right?
No.
Clarify that for me.
Yeah, when the litigation starts over again in court, discrimination, retaliation is de novo, meaning that the question of whether discrimination or retaliation occurred remains in the first instance in the purview of the judge, and then overcoming the summary judgment hurdle, it remains in the purview of the jury in the Superior Court.
Thank you. If I can continue with one further. So taking Senator Gannon's example there, if the situation proceeds as you say, as he suggested, well, the employer could, in that intervening 2-year period, have counseled the supervisor that might have caused the initial harassment or the initial complaint, such that there is no further violation that occurred in that window between the Human Rights Commission hearing and the court's hearing. Would that would change the matter significantly. The complainant would have to claim something that existed in the past that doesn't exist currently because the employer took some action.
Well, if using our example, pro se Jason, when he files a charge at the commission, what he'd be asking for in the way of relief is to ask the commission to intervene to stop the harassment, but also to compensate, ask the commission to order his employer to compensate him for the emotional harm that he's suffered until they took the appropriate steps to fix it. So that loss would still be there and would be, I think, entitled to remediation. But of course we're very pleased. And this has happened to me in my practice to my great great pleasure, Employers Council has come to me and said, you know what, we recognize we have a real problem. We want to offer some monies to your client to correct the pain, the hurt, the emotional hurt that we caused, but we promise you we're going to fix things going forward. And these cases, I'm thinking of one that resolved, guess where? At the commission that way. The commission is the place where that happens, in my experience. Okay.
Are there any further questions?
My apologies.
Okay. Seeing none, thank you.
Thank you.
Just for the committee's reference, thank you, Ms. Horgan, for bringing up Senate Bill 509. It was heard in Senate Judiciary on the 5th of March, 2020, and on the 16th of June, 2020, it was vacated from the committee and laid on the table. Okay, we have one final speaker, Samantha Herring. Is that correct?
Herring, very close.
Okay.
Thank you, Madam Chair and committee members. My name is Samantha Herring. I'm an attorney with Douglas, Leonard & Garvey as well, and a large portion of my practice also focuses on employment law. I want to give you another real-life example about how this might play out, and I've also got a fact sheet for your reference. Thank you. But before I get into the real-life example, I see Senator French's summary of this bill as setting it up perfectly. It's just a simple fairness issue.
Thank you.
And this is a bill that benefits everybody. It benefits businesses, it benefits the employees, and it benefits the conservation of this state's resources. The beauty of the commission is that it's an informal, inexpensive process where people can proceed easily without an attorney. As Attorney Douglas testified moments ago, if you go back to square one and you start over in court, that 1 to 2 years of resources and time that the commission expended getting to a PC finding is all a waste. It was for nothing. And for the plaintiffs who don't give up and they choose to pursue their case in court, now we have to wait another 1 to 2 years until trial. So now we're using duplicative resources, this time in the judicial system, to resolve a case that was on the cusp of resolution at the Human Rights Commission. But another example of a way this might play out is for somebody who has a disability. And let's use the example of someone who works at Hannaford's grocery store and they have Down syndrome. They're a valued good employee. But some of their coworkers and managers use this person's disability to demean them. They call them Forrest Gump. They call them an imbecile. This person wants to keep their job and keep working, so they go to the commission. They file a charge of discrimination. They're relieved to find that they don't need an attorney because they can't get one. Because the way that their case is structured, there's no way for the attorney to be compensated for their time. And the person is a low-wage earner who can't afford to pay attorney's fees on an hourly basis. So they proceed through this commission process. They get to the PC finding, and then that's the moment at the end of the entire process when the employer gets to remove and make the person start over. As I mentioned earlier, it's not just an injustice for Jason that he has to go back to square one. It's an injustice in the sense that we're wasting our state's resources that could be put to better use. And I'm happy to take questions at this time.
Thank you very much for your testimony. Are there questions from the committee? Okay. Seeing none, thank you very much.
Thank you.
Next, we're going to call Ani Malachi.
Good afternoon again, everyone. Ani Malachi for the record, Human Rights Commission Chair, Executive Director. I have so many jobs in my head right now. So I really wanted to just primarily make myself available if there were any questions about our process. And we, the commission, worked at least in the beginning stages with former Senator Levesque when she pulled together the information for SB 509 last session. And certainly we had a meeting and talked about what our process was so that there was clarity and understanding of what we do and how we do it. And so I'm offering the same information here if there are any questions. Yes.
Okay. Thank you very much for your testimony. Senator Whitley has a question.
Thank you, Madam Chair, and thank you for coming and providing some support. So you probably heard the prior testimony, and is it sort of your assessment based on the cases that you see that are resolved that, adjusting the process a little bit would lead to a greater chance of resolution for these types of cases?
What was the last part? A greater chance?
That it would lead, that this bill might, have a better chance to lead these cases to a resolution within the commission? Would you agree with that?
So that's a really good question because it's kind of all over the place, and almost in a good way. So when people come and a charge is initially filed, both parties are notified, and from the very beginning, the commission will present information verbally as well as in writing that people have an opportunity for mediation. We offer a free mediation program, and in looking at the other human rights commissions of a similar name in New England, some have it mandatory, some have you pay for it, and others it just depends. We have volunteer attorneys, certified mediators, and judges, or former judges, who volunteer to mediate charges with us. So that is one opportunity someone has at the very beginning of the process to potentially have a resolution. If that doesn't take place, or if one party or the other is not interested, then it will move on to a full investigation. Once it's assigned to an investigator, that investigator will also ask again, are you interested in mediation? And it depends on a time frame. So if it's been a little while before it's been assigned, then they will still ask up front, are you interested in mediation? And that investigator can work on a settlement agreement between the two parties, and then it's done. Those that are not interested, then the investigation pursues or moves forward, and then there's a finding. And so with a probable cause finding, what has happened, sometimes complainants will go to an attorney, and the attorney may or may not think the case is strong enough, but because of the statute, they file with us first. So they may advise them, go to the commission first. Let them do their investigation. We can say they're helping us stay in business, if you want to call it that, or they're utilizing our investigative services so that part is done for the private attorney, however you want to look at that. And then once there's a probable cause finding, that individual can take that finding back to that attorney, and that attorney potentially would then pick up the case. And that person could be represented by counsel. And I forgot to say in the very beginning that as a complainant, you do not have to be represented by counsel, but even as a respondent, you don't have to be represented by counsel. So our process does not require it. And if that complainant, because that's who we're focusing on mostly right now, if the complainant does pick up counsel and they become a part of it, then the next thing after a probable cause finding is a conciliation. And for the non-lawyers, it's just mediation after a probable cause finding. If that if that conciliation is not successful, then we schedule a hearing. But oftentimes during the conciliation process, they come to a conclusion and there's a financial settlement. There are times when that does not happen. There are times where the complainant will do their due diligence and file with us initially, but because they are initially represented by counsel, before an investigation or a probable cause finding takes place, then they will withdraw the charge, and then the represented complainant will then take it to court and fight there. Of their own free will. And there are times where after a probable cause finding, the respondent will then remove it. So at probable cause, that is the only time that a respondent can remove it. Prior to probable cause, a complainant has the ability to remove it. Technically, it has to be with us for 6 months, but we will allow the complainant to, in writing, request to withdraw. And usually it's because they're represented by counsel. There are other remedies that court can provide that the counsel cannot, that the commission cannot. And so they may do better going to court. So they will write to us to request a withdrawal, and we will approve that, making sure all the documentation is in place. Long answer to a short question. And it could be beneficial, I believe, and I apologize for not having current figures. I mean, we closed 200 cases last federal fiscal year. So I would need to look up the numbers again, and I'm happy to email the committee. But I think previously, when I was working with Senator Levesque, I believe when we did sort of a 5-year look back, the cases that had been removed, they were pretty close in terms of who removed the cases. And of the ones removed by respondent, there were a few complainants that were not represented. But within the last federal fiscal year, that certainly could have changed. So I would be happy to get that information and email the committee.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much for your testimony. Are there any other members of the public that would like to speak to Senate Bill 296? Okay, seeing none, we'll close the public hearing. We're going to go ahead and open the public hearing on Senate Bill 293 FN and recognize the prime sponsor, Senator Whitley. Good afternoon, Senator.
Good afternoon. Thank you, Madam Chair, and good afternoon, members of the committee. For the record, my name is Becky Whitley, and I'm honored to serve New Hampshire Senate District 15, which includes the communities of Concord, Pennacook, Henniker, Hopkinton, and Warner. So as a mother, I'm very honored to bring forth today Senate Bill 393, which limits the type of restraints used on pregnant people who are incarcerated in New Hampshire jails and prisons, and addresses the issue and use of shackling during transportation for these folks. This bill also establishes a reporting requirement when shackling is used under the amendment. So in general, before I talk about the amendment, I think it's important to provide some of the reasons why this is an important bill and why we need it in New Hampshire. So in general, shackling pregnant women can pose serious health risks to both mom and baby. Medical experts say that shackling poses safety risks that include the potential for injury or placenta abruption caused by falls, delayed progress of labor caused by impaired mobility, and delayed receipt of emergency care when corrections officers must remove shackles to allow for assessment or intervention. So in that same vein, the American College of Obstetricians and Gynecologists, otherwise known as ACOG, supports policies restricting the use of shackling on incarcerated people throughout pregnancy, labor and delivery, transport, and postpartum recovery. They indicate in their policy statement in support of bills like this that shackling interferes with the ability of clinicians to safely practice medicine and may put the health of the pregnant person and fetus at risk. So I also wanted to point out that women that are subjected to restraint have also been shown, subjected to restraint during childbirth, also have been shown to report severe mental distress, depression, anguish, and trauma. This is according to the American Psychological Association. From that same study, we know that shackling during or immediately following childbirth can cause or exacerbate pregnancy-related mental health problems, which we know many moms do suffer from, including depression and post-traumatic stress disorder. So I also wanted to point out, thinking through who these pregnant people are. Women who do get locked up tend to, on average, have suffered more childhood traumas. We know that. Being shackled can increase post-traumatic symptoms that caused by prior experiences of trauma and could be re-traumatizing for them. Regarding sort of safety concerns, I think that as someone who has gone into labor myself, delivered a baby, as others may have also, I think it's pretty clear that a woman's ability to harm others or flee is very limited during pregnancy and labor. That's just a sort of biological fact. So what we wanted to do in this bill and in the amendment is really try to balance all the interests here. We want to make sure that mom and baby are safe, but of course we also want to keep the public safe and everyone in our corrections facility, all the staff, medical staff, we want to keep them safe. So in that vein, we did touch base a number of times with Commissioner Hanks, who is here today, the New Hampshire Association of Counties, to hear their concerns and how we can better balance those really important competing interests in this bill. So you'll see from the amendment, you have the amendment before you, amendment, 0125S. And I'll just take you through that a little bit. Oh, thank goodness he's back. I was just about to describe the amendment, Senator. So the purpose of the amendment was to try to balance all the interests here, make sure we're keeping corrections staff, medical staff safe, but also making sure we are doing our very best to protect moms and babies. So we added language in the amendment, creating an individualized assessment of whether there's evidence of imminent risk of escape or harm to the pregnant person or others. That's in section 4, so that's the transportation section. We also clarified the section on the availability of female correctional officers. We heard, of course, we all know that there's some staffing issues. So what we have in there is essentially a preference for same gender correctional staff when a pregnant person is going through this process. So you'll see some amendments to that language. And then we also, that's section 3, and then also in section 3, we made an amendment to clarify the balance of interest between the privacy of the pregnant individual with, of course, the public safety concerns. And so we feel like we came to a great balance on that, and we were very grateful to the folks that provided their input and really truly hope that this amendment reflects all the interests here. So I'm happy to take any questions. I will say that there are a number, in drafting this bill, we worked with a number of OBGYNs, and they did not feel comfortable just because of safety issues coming to the State House, nor, of course, they have busy practices, so they will be providing letters of support, sort of outlining their medical concerns and support for the bill, so please look for those in your email, but I'm happy to take any questions.
Thank you very much, Senator. Are there any questions from the committee? Okay, seeing none.
Great.
Thank you very much.
Thank you.
The chair will call Helen Hanks. Good afternoon, Commissioner.
Good afternoon. For the record, Helen Hanks, Commissioner of the Department of Corrections. Thank you, Honorable Chair and members of the Judiciary Committee. The testimony you have before you is plainly written based on what is publicly posted associated with this bill, and we want to first extend our appreciation to the prime sponsors of this bill for the opportunity to see the amendment. If this committee passes the amendment, the department stance from opposed to as written would be in support of this fully drafted bill. I would like to give some history. This agency, as early as 2014 and 15, the attachments to our testimony looked at best practices in the use of restraints with women who are incarcerated and pregnant. And we made sweeping adjustments to our policy, which I also included. We haven't updated our policy, understanding this bill was forthcoming to make minor adjustments, but you'll see most of what is proposed is aligned to our policy and practice. We further agreed many years ago that women in delivery would be very difficult for them to attempt to escape. I have 2 children as well. And we have, for quite some time, met the requirements of the Prison Rape Elimination Act that does look to same gender supervision absent exigent circumstances. So again, with the amendment, if the committee adopts it, we're in support of this bill, its intent, and it would preserve what the state of New Hampshire would expect in correctional settings associated with women who are pregnant. And in the testimony as well, I thought it would be relevant. I provided a fiscal year analysis of women who have been incarcerated just in the state correction systems. And what you'll find is what we work very hard at is to help women return to the community prior to delivery if it's appropriate and safe. Otherwise, you'll see a smaller number of women who actually do deliver while in custody. So with that, I also have the warden of the New Hampshire Correctional Facility for Women, Nikki Plant, with me if there are questions that we could offer and assist with.
Thank you very much for your testimony. Are there questions from the committee? Okay, I just want to make sure that I heard you correctly. You were discussing Amendment 0125S that
Yes.
the Department of Corrections supports.
Yes, thank you for that.
Thank you. Any further questions? Senator Whitley?
No, I just wanted to thank the commissioner for, always providing, being transparent with data, always providing information, and always being willing to collaborate to balance all the important interests at stake here. So I just wanted to express my appreciation.
Thank you, Senator Whitley.
Senator Khan?
Thank you, Madam Chair. Welcome, Commissioner. Thanks for your testimony. I'll look through your packet, but I think quickly your summary and your bar chart, describes that since you've taken this under review in the department, the uses of restraint are minimal. Do I take that right?
That's correct. When we adopted the policy attached, it aligns very cleanly with most of what's proposed today and to preserve in statute.
And that yeah, thank you. And that's the point of the takeaway here, I think, that while you've minimized the uses of restraints within the department, placing this into statute provides some assurance that the practices that have been put in place remain in place and that you can train to the statute.
Senator Khan, that's a fair statement and what I expect this fine legislature always to consider. What preserves the life of us after we're gone, right?
Thank you.
Are there any further questions for the commissioner? Seeing none, thank you very much, Commissioner.
Thank you so much.
The chair will call Frank Knack.
We might want to take Senator Prentice. She said
Where is she?
she's just here and she has to leave at 2:30, if that's okay.
Oh, okay, I've heard. She doesn't want to speak? Okay.
That's actually.
No, please, have a seat.
Madam Chair, members of the committee, thank you so much for the opportunity to testify today. My name is Frank Canack. I'm the policy director at the ACLU of New Hampshire, and we're here in strong support of this bill. I'd like to first thank Senator Whitley for bringing this important bill and for Commissioner Hanks for being out in front of this before we even had to get to the legislation. In addition to the notes that Senator Whitley provided with the committee at the onset of this hearing, I'd just like to also point out, in addition to ACOG, the American Medical Association, the American Public Health Association, the Federal Bureau of Prisons, the U.S. Immigration and Customs Enforcement, and the American Correctional Association all support the prohibition of shackling non-pregnant people with certain exceptions. In addition, the First Step Act, signed into law in 2018 by former President Trump, also prohibits the shackling of pregnant people in federal custody, except with certain exceptions similar to what are outlined in this bill. So I don't want to overdo my welcome, but we love this bill and we really appreciate it, and I have some testimony if it'd be appropriate.
Thank you very much for your testimony. You can please hand your written testimony to Ms. Horgan, and she will disseminate it to the committee. Sir, I just want to clarify, have you seen the amendment?
Yes.
And are you in support of the amendment as
Yes.
well? Okay, thank you. Senator Whitley has a question for you.
Thank you, Madam Chair, and thank you for your testimony. So can you just clarify what the federal law does? I mean, it's not the same as the bill we had before us, but do you think it aligns with what we're trying to do here? Can you just point out some similarities for us?
Definitely. I don't have the specific language of the federal bill in front of me right now, but in general and broad brushstrokes, it prohibits shackling of pregnant people in federal custody except when it's necessary to prevent serious harm or escape, in which the least restrictive means are to be implemented. So very much in line with what this bill is attempting to do. And it also, in addition, it has similar reporting mechanisms in place, similar to the bill that you brought forward, Senator Whitley. And I'd be happy to get the committee that I believe the citation is in the document I just sent. It is footnote 11 in the document I just circulated.
Okay. Are you all set?
Set.
Okay, are there any further questions for Mr. Knack? Okay, seeing none, thank you very much.
Thank you all so much.
Are there any other members of the public who would like to speak to Senate Bill 393? Senator Prentice, you wish to come forward?
Sometimes I smile and I forget that I still have a mask on, so. Good afternoon, and for the record, my name is Suzanne Prentice. I'm a state senator from District 5, so our Connecticut, 9 communities in the Connecticut River Valley. I'm here in support of this bill. I'm a co-sponsor, worked with not just Senator Whitley, but stakeholders from the state system and the county system to bring before you, or to put the language together for the amendment that you have today. I think that what we all know and what we all want is to balance the needs of moms, their babies, and the communities that they are within. So this bill, well, we know that pregnant moms have different needs. We're not just talking about laboring, we're talking about their center of gravity, and so they have some particular medical needs that we want to be careful because they're more prone to falls. And then we have the issue of when they're laboring and delivering their children, which puts them in a unique category. So after listening to what, again, the state and the county officials brought to us, I believe that we're able to strike a much better balance to protect all that were involved. So that's just what I wanted to offer. And thank you. I ran over, and now I'm going to run back, but I would be happy to answer any questions that you have.
Thank you very much for your testimony, Senator. Are there any questions from the committee? Okay. Senator, I just have a quick one. Have you seen amendment number 0125S?
I have.
Are you support that amendment?
I support where we came in with the bill, but the amendment makes it much better and provides the balance that we need after really extensive conversations with stakeholders.
Okay. Thank you very much.
You're welcome.
Are there any further questions? Seeing none, thank you very much.
Thank you very much.
Okay, last call. Are there any other members of the public who would like to speak to Senate Bill 393? Okay, seeing none, we'll close the public hearing. We're a little behind, but that's okay. Bill, I'm the next person.
What's that? What time did you say?
Yep,
Yeah. Money Hastings in the house. I used to see you when I was, yeah, not that it was a long time ago. You used to teach all my seminars. I know, a long time. Senate Commerce, shall hear. SP 430.
No, we're judiciary.
Oh, I'm sorry.
Yeah, you gotta turn on your mic.
Looks like there's some Harold here. All the players are the same. But again, Judiciary 431. Thank you, Senator. Go ahead.
Good afternoon, members of the Senate Judiciary Committee. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn, and I have for your consideration this afternoon Senate Bill 431 FN, relative to child support in cases with equal or approximately equal parenting schedules. This bill establishes methods for adjustment of child support for equal or approximately equal parenting residential responsibilities. This legislation has been proposed by the Child Support Working Group. Those of you who have been around judiciary for a while knows that this is a very hard-working group, and they've brought legislation in front of us before. And we've got a lot of folks that are going to be testifying on this bill. So what I'd like to do is just ask you to hold your questions for the people that the working group that got together and did the work on this, and they can answer your questions better than I can. So thank you all very much.
Senator, does anyone have any questions? Thank you, Senator. Honey Hastings, come on down. I watched a lot of Prices Right when I was young.
Yeah, that's okay.
Thank you, Senator Gannon.
Good afternoon, Ms. Hastings.
Good to see you. This bill solves is what is the appropriate child support where the parents have equal or approximately equal schedule with the child or children. Under the current law, it's really hard to determine. In fact, the law doesn't tell you the answer. RSA 458C presumes that the guidelines are correct, but then says there may be an adjustment, and any adjustment for schedule reasons is subject to a three-part test. It doesn't say how much the adjusted support should be. And the three-part test, to be frank, including a trip it's taken up to the Supreme Court, has not really been that helpful. In the 16 years since the Parental Rights and Responsibilities Act was adopted, more and more families are adopting these equal or approximately equal schedules, meaning the question's coming up even more. The problem is, what's the support? As a result, there's more litigation than I as a mediator would like to see. There have been many bills put in both before parental rights and since to try to solve this problem, but none have passed. Our group, thank you for your kind words, Senator, spent a lot of hours over Zoom, over several months, and we came up with criteria first of what such a bill should be. The first is it should be fair to the child. Second, it should result in a reasonable lifestyle in each home for the child. There shouldn't be substantial differences. It should be understandable, even to self-represented parties. It should distinguish between those cases where the guidelines, which are presumed to be what the support should be, where that's appropriate, and where those cases where an adjustment is appropriate. We think it's very important that any bill continue the long-standing requirement of an equal or approximately equal parenting schedule to be considered for an adjustment. So there's the problem, there's the criteria, and here is how we think 431 solves it. It has an improved test for deciding if the child support should be adjusted. Best interest and similar lifestyle for the child in both homes. Where it would be fair for the child, and we've got a mathematical test for that, It offers the net the difference formula as one option to be considered. The test for determining whether net the difference would be appropriate is that the higher income parent earns less than 60% of the total income. Based on our calculations, and my colleague will review the arithmetic with you and show you some things on a spreadsheet, we found when the differences in income were too great, it really left the child in a bad situation, under-supported by a high-income parent who could afford to provide the support. So that's the overview of what's in it. The Child Support Working Group, some of which appeared before you as the Alimony Working Group, slightly different composition, but we have a bunch of divorce professionals and representatives from New Hampshire Legal Assistance. By the way, there's written testimony from them. They're not appearing in person. And also the Association for Justice. Because of our concerns in 2021 about House Bill 161, which now is House Bill 1647 with a couple of tweaks, we got together to testify last year about the shortcomings. And we committed in this room to this committee to come up with a bill that would solve the problem. Senate Bill 431 is that promised bill. There are other efforts in this legislative session to solve the problem. As I mentioned, 1647 is essentially or very similar to 161, which this committee recommended an expedient to legislate last year. Unfortunately, it doesn't meet any of the criteria that I reviewed with you above. It lowers the threshold for cases that would get an adjustment to 30% of the overnights, which I don't know. I've done this work for a long time, but I can't say right off what is 30% of a 2-week period. Most parenting schedules are figured out on a kind of 2-week period. I'm not sure what that would be. It would so expand the group of eligible families and encourage fighting over each night. Who gets this night? There I would call your attention again to the New Hampshire Legal Assistance written testimony, which talks about the impact of this question, this argument on domestic violence victims. It is so confusing that even as a bunch of divorce professionals, we found the multi-part formula hard to navigate. And the examples that they had in the UNH study, incomprehensible. It ignores who would pay for daycare and other major expenses. That's a big problem once you start changing the child support. There's another bill, House Bill 228, which was recommended ought to pass in the House in Children and Family Law just recently, and that would use the net the difference formula in every case. With net the difference, you take the support owed by the two parents, subtract that, and that the difference between what parent A owes in support and parent B is the amount that the high-income parent pays. That bill, 228, would have that apply in every case. Again, we feel it's unfair when the differences in income are too substantial. I'm not going to go over the part of the formula in the scenarios. My colleague will do that, but I would like to briefly walk you through the bill, just so it's really short. It essentially has a new section in 458C5 called 5A, and this would now have all the provisions that deal with child support in equal or approximately equal cases, instead of having it in the middle of a laundry list of reasons why you can vary the guidelines. So it retains there are 9 Roman numbered paragraphs. And the first one is exactly the text from the existing law. Equal or approximately equal parenting residential responsibilities in and of itself shall not eliminate the need for child support and shall not by itself constitute grounds for an adjustment. We think that law has worked and we want to keep that. On paragraph 2, line 8, this deals with our 2-part test. Any adjustment has to be best interest and that there's a similar or approximately equal style to the other parent. Number 3, as the factors for the court to consider in making findings to support an adjustment. That's on line 14. And we list some of those things: adequacy of housing accommodations, nutrition, transportation, technology, availability of education, educational materials, extracurricular activities, travel and entertainment, any other factors in the child's best interest. Line 21 deals with what happens if the guidelines adjustment would result in an unequal style. Well, if the lower income parent is not able to meet the cost in a similar or approximately equal style, guidelines shall be ordered. Line 24 deals with parents reaching agreement. Again, that's in the existing law. We're trying to get it all in one section, 5A. So these would, if the parents agreed to allocate fixed costs, then that would be a reason favoring an adjustment. Line 28 has a list of some of the variable expenses that we might be talking about there. On page 2, line 3, this is very important because it deals with the daycare costs. Again, when you get daycare, it's so expensive, especially for younger children. If you don't factor that in and you lower the child support, there's going to be some unfairness. So we're saying if the court makes an adjustment, uses what I've told you already, the test, says, yes, this is a case to adjust, then the court has to also assign the daycare costs. Could be split, could be the high-income parent, they just have to deal with it. Paragraph 8, this has the test for using the net to difference, that is, the larger income, the higher income parents' percentage of gross income is less than 60% of the total. And it shows how to do that. Calculate the support based on both, determine the guidelines obligation for each, support the lower one from the higher one. Again, this would only apply where it meets that under 60% test. If it doesn't, if the net the difference do not meet the criteria above, best interests of the child, lifestyle, etc., then the court can either order guidelines or some other amount that does meet the criteria that we set out. This, we also have an applicability section, so important when changing these kind of numbers. You don't want every child support case that's been through the court in the last 10 or 15 years to come back and get it redone because of this law. So it says, and this is on line 18, that if you already have an order, this isn't a reason to change the order or modify the order. When your 3-year time period comes up, or there's some other reason to adjust, then this formula could be used. Old cases can't come forward just because the law has changed. And line 21 indicates we remove so much from 5, we then kind of put a Band-Aid on 5 and say, make a cross-reference to the new 5A. And it calls for an early effective date, because this is remedial legislation. This area needs to be fixed.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Senator French.
Thank you, Madam Chair, and thank you for your testimony today. Does this legislation take into consideration the combined incomes of non-married couples that are together after the split?
It's a good question, Senator French. In New Hampshire law, there's no distinction between married couples getting divorced, married couples getting legally separated, and never married couples. The law is the same for all. If you have a child together, this law applies.
So
follow up.
Yeah, I understand that, but say this couple gets divorced, when they factor in, say the husband moves in with someone else, when they do the factor of the income, do they take the husband and his live-in income into consideration, or is it just the husband's income?
Only parents' income counts.
Okay.
Are there any further questions? Seeing none, thank you very much, Ms. Hastings. Next, we'll have Tony Matamulo. Excuse me.
Thank you for giving me the opportunity to testify today. My name is Anthony Matamulo. I'm a certified family mediator, and I have an office in Londonderry, and I work every day. I have clients, I have parents in my office virtually every day struggling with this issue. And the main reason that they struggle with the issue is because there is so much ambiguity in the current, not only in the current law, but in the information that they receive from various sources before they sit down to try to discuss the issue. And so it is very common for me to have clients show up in my office and to have a situation where one client earns $10,000 a month, the other parent earns $2,000 a month, and the higher earning parent says that they have been told that if they agree to an equal parenting schedule, they will not be required to pay child support, which obviously is not what the current law states, but it's evidence of misinformation that's out there. So conflict over this issue is basically is born from different expectations. So in the current law, people can come into the room believing that the range of outcomes they may get if they are not able to agree on an appropriate amount of child support could be anywhere from 0 to the guidelines. That is a big playing field for people to have conflict over. So what helps resolve conflict, and I've worked with hundreds of families through this issue, what helps resolve the conflict is to narrow the playing field so that they're not coming in thinking this is going to be anywhere from 0 to $3,000 a month, and now they're having this discussion that goes on and on and on. So what this does, what this bill accomplishes, and one of the objectives we had was to narrow those parameters. I like to use the analogy of placing bumpers in the bowling alley. So if we can move that bumper from 0 to some other place, it changes the entire discussion. I will say that I have never had a case where people were not ultimately able to agree or settle the issue of child support, but sometimes it is a very grueling, destructive process. And even when they agree on it, you know that that there is not 100% buy-in that the number that they came to was the right number for each party. They may have agreed to it, but they don't have the feeling that you hope they leave with. And I'm saying this is in a minority of cases, but it does happen. So since there are so many permutations to the individual facts of any case, so many different things that are in play, and since we do want parents to have some decision-making and ability to deviate and to come up with a number that they believe is fair, taking into account their specific situation, there is no formula that is going to solve every situation. There is no set of a few formulas that are going to solve every situation. So what we try to do is to limit or, again, create those narrower ranges of outcomes for certain situations, and this equal parenting schedule is one of them. So there are two factors. First of all, if you believe, which we believe, and there's evidence, there's studies to show this, that children do best when they are living an approximately equal, reasonably equal standard of living in both households, so that they don't view one parent as able to provide for them and the other parent as unable to provide for them. So that if a child, and I've been in these conversations so many times, where one parent says, well, I won't pay child support, but if they need shoes, you let me know and I'll get them shoes. That is not a situation that's viewed to be beneficial to a child, to feel like one parent has to go to the other. The purpose of child support is so that the income of the lower parent is supplemented in a way that they can provide for the child too, and that the child perceives each parent as able to do that. So when we were approaching this, there was a feeling that this net the difference formula, which has been used in cases, became kind of a practice in some cases, that we tried to maintain that. I know that's been the subject of other bills that have come in front of the Senate and the House. And so we embarked on an extensive statistical analysis to determine. We had the guidelines on one side and we had net the difference on the other side to see if we could find and identify those cases based on incomes where net the difference would be an appropriate option to offer. Not that it is the presumed amount or it replaces the guidelines, but that it would be an appropriate option for people to consider. So as I said earlier, move the bumper in the bowling alley from 0 to net the difference on the low end, right? And you've got the guidelines on the high end. Now you've got people playing in this arena where they understand where that is. And this statistical analysis resulted in the spreadsheet that you have in front of you, which determined that if the higher earning parent earned less than 1.5 times what the lower earning parent earned, or 60% of the total combined gross monthly income of the two parents, that net the difference would be an appropriate option for them to consider. That would be in the arena of what a judge might, this range that a judge might consider, right? Not 0, not $10 a month, but this net the difference. So, and if you look at that analysis, you can see we have here 5 different scenarios with various income levels. But if you look at the first 2, in those 2 cases, you can see that the obligor's monthly income is less than 60% of the total combined monthly income. So the highlighted amount of child support under the net the difference calculation of $148 in scenario 1 and $17 in scenario 2, if you look in the last column, that's what it would result in when this child support was paid by one parent and received by the other. The difference in their incomes, the disparity in their incomes, which is the main determining factor as to whether or not they are going to be able to provide that approximately equal lifestyle in each home, you can see what the result is. In the first scenario, the difference between the incomes before child support was $750. Using net the difference, it brought that difference down to $454. In the second scenario, it went from $417 difference down to this $383 difference. So those are modest adjustments. It didn't flip incomes, because that isn't the purpose of child support, or even to equalize incomes. But what it does is it brought the incomes closer together so that it is reasonable to assume that each parent could provide a reasonably similar lifestyle in each home. If you look at the last 3 scenarios, and you look at the child support guidelines would be the presumed amount, or the upper end of the bumper in the bowling alley, right? Because the obligor's income exceeds 60% of the combined gross monthly income. So in those cases, you can see that even after paying the guideline amount, the upper end of the bumper in the bowling alley, you've got income disparity in 3 of $1,550, in 4, and it went from $3,750, which was the difference before child support was paid, down to $1,550. In scenario 4, it went from $7,917 down to $4,833. And in the last scenario, it went from $16,667 down to $11,000. So you can see that this does not flip incomes. It does not equalize incomes. It allows for each parent a reasonable opportunity to provide a reasonably similar lifestyle in each home. And again, this was based on a very extensive statistical analysis. I won't go into the weeds anymore about this, but I'm certainly happy to answer any questions any of you might have.
Thank you for your testimony. Are there any questions from the committee? Seeing none, thank you very much.
Either you're sick of hearing from me or I did a good job of explaining. I don't know.
No.
But thank you.
Next, the chair will call Marianne Dempsey.
Good afternoon, Madam Chairwoman, Senators. For the record, my name is Marianne Dempsey. I'm General Counsel for the Judicial Branch. The Judicial Branch has no position on the substance of this bill. We emailed the chair last night about a very limited issue, which is the effective date. We would request that the effective date be changed. The presently the bill provides for it to take effect June 30th, 2022 by statute. And the statute references in the letter that folks have where it would affect the judicial practice and procedure. We would ask that that be amended to be January 1st of 2023. In reviewing the fiscal note, it appears that HHS would also need time to update certain forms as well. So I'm happy to take any questions, but it's a pretty discrete issue that I come to testify about today.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you.
Thank you.
The chair will call Michael Dinan, D-I-N-A-N?
Yes, you pronounced it correctly. Thank you. Whoops, and I think I gave you 6 copies. Good afternoon, Madam Chair and Committee. Thank you for having me today. My name is Michael Dinan. I live in Northampton, New Hampshire in Rockingham County. I've been involved in this probably since 2018, since child support guidelines were established. And I fully agree with all the other speakers that some kind of reform needs to be done on child support guidelines. I'd like to read a somewhat, I was just handed out to you. I think since a lot of this has been addressed, I'll talk more to the specific points. But New Hampshire state guidelines are very perverse, I would say, detrimental to New Hampshire children. To add to what everyone else is saying, that it is not the Wild West out there, but since Silva v. Silva was established in 2018, it became precedent case law. And since then, the guidelines, and to reference the same thing that Honey Hastings had mentioned, stating that equal or approximately equal child support parenting time is not grounds for deviation from child support guidelines. So when that was enacted by Silva v. Silva, it actually put all the funds going to one parent. And I think it's a good time to read from this. So since Silva v. Silva became precedent case law in 2018, if one of the parents makes even $1 less than the other, that parent receives the full and entire child support amount that was intended to be shared across 2 households. And that's shared parenting responsibilities that we all agree are there. This creates a devastating environment for New Hampshire children where only one parent is given the means of providing a suitable home and lifestyle for their children, while the other parent is left with no means of adequately providing or being involved in any decisions for the well-being of their children. This is an important part because it was just mentioned that the low-earning parent has to be able to keep the children in a lifestyle that equal or approximately equal to the other home. In the case since Silva v. Silva, in my case and many of them, the higher earner parent is not able to keep the children in a lifestyle that is suitable for them or equal to that of the lower earning parent. And I'll get into the specifics of this. So the disparity and imbalance of these funds often leaves the higher earning parent in an indigent state, leading to long-lasting harm to the New Hampshire children. If one parent does not have the means of supporting themselves or their children, it causes a downward spiral that drags down the entire family, as it does New Hampshire as a whole. This litigious nature of the current guidelines and the need to correct them is enough to cause most parents to lose grip on their own lives and their children's well-being, including putting the burden on an already overwhelmed family court system. And this is the important part. Per current guidelines, the income of the lower earning parent's income has barely an effect on the amount of child support that the lower earning parent receives. This also promotes that parent to not seek adequate work or income. This lowers the overall amount of funds available to raise their children, which the higher earner already has no input on how any of these funds are used, since all the funds needed to raise the children are allocated to the lower earning parent. Whether the lower earning parent makes between 0% of the higher earning parent or even 99.99%, $1 less than the higher earner, the obligor, it barely changes the amount of child support provided to the lower earner, the obligee. And what I did is provided some examples, and they're in the back of what was handed to you, that show both of those two scenarios. In the first one, it's the second to last page, you can see that the obligee, the lower earner parent, is assigned $1. The higher order parent has an annual income of $120,000. That ends up being $10,000 a month. Per the calculations, the lower earner receives the full child support guidelines of $2,155. The last page shows if the obligee earned $1 less than the obligor, meaning the lower earning parent makes $199,988, which is $1 less a month than the higher earner. It results in a child support guideline of $1,875. Deducting the difference, it comes up with exactly $280 difference. That's whether the lower earning parent makes $1 or less or $0. It doesn't change the amount they receive, roughly $200 a month. So per these current guidelines, all the funds go to the lower earning parent. The intent of these guidelines was to have the amount spread across both households because there is equal responsibility that both households can be maintained in an equal amount. But since Silva v. Silva, all the funds go to the lower earner. Promotes the lower earner out to work, removes the ability of the higher earning parent to have any input on the well-being of their children. As has been heard so many times, this leaves the higher earning parent with no means of supporting themselves or their children. And this is not an exception. This is the reality for most New Hampshire families who have had child support guidelines established since Silva v. Silva in 2018. As previously established, child support orders are reassessed every 3 years. All will follow these perverse and detrimental calculations. Every 3 years, child support guidelines are reassessed. You have an opportunity to go back and have your case heard again. So since 2018, we're now 2022, most all the cases will follow this. So this is not the exception, which is what many want to say when talking about the detrimental impact of these guidelines. What ends up being promoted is the overwhelming burden this puts on families who are forced in court to provide, protect, and help their own children, and the courts themselves who are already overwhelmed as the usual children end up suffering. Just to mention Anderson v. Anderson, this was a case that was actually is referenced in a lot of these discussions. It was in November 26, 2019. The judge himself said, I don't make laws, I enforce them. He said, it's not our role to create legislation. Accordingly, we leave this to the issue of the legislature, meaning that it's put back to all of you and the legislature to come up with something that actually does work. So to get through this kind of quickly, and more information is available, and I'm very pleased to answer any questions. This precedent that Silva v. Silva is a reality for everybody. It's not an exception. There are no deviations. That Anderson v. Anderson was mentioned to show that. What happens, though, is, in my case in particular, I'm left, all the funds go to the other parent, the lower earner. So as the higher earner, I'm not left with the ability to keep them in a lifestyle that is similar to the lower earner. All the decisions, because there's something called CODARE, it's not even needs to be mentioned, but since all the full guidelines are paid, I have no ability to affect extracurricular activities, clothing, things like that. So I, in effect, if I want them to do a summer camp, if I want them to have some clothing that they're not provided for, I have to pay out of pocket again in addition. And the intent of those guidelines is to be spread across both households. So to get down to 431 and what's so important about the discussion today, you know, the Carsey School mentions this. It's very clear that, you know, since 2018, this has become worse. It's the guidelines, the Carsey School kind of study is on the DHS website if it needs to be referenced. Well, so to talk about 431, and I agree something needs to be done. 431 has some good points, but the calculations that are used are going to cause, and also the language would cause more confusion. I just want to talk about this quickly. 431 will turn Silva v. Silva from precedent, case law, into actual legislation. It'll further damage already broken and devastating, a broken and devastating child support system. It provides very confusing and highly subjective language that would only worsen the overburdened state of New Hampshire family courts. I don't need to mention that who I think will benefit of this, because it'll cause more litigation and cause more hearings and more time in court and more lawyers' fees. But a very important part about this, and it was just mentioned that all the statistics that were mentioned, is that it's, and this is kind of incontestable, higher versus lower is 50-50. If we take 49 and 51, you would say that 51% is the higher earner. Between that threshold of 51 and 60 is this sweet spot that 431 addresses. That means that someone has to be the higher earner, but then also make just less than 60% of the total available income, the combined income. That leaves a 10% window where any of 431 would do anything to change current guidelines. That's the only small window that it would create. So if someone makes 61%, they make more than the allowed amount. It's going to create, that's the only scenario when that small 10% window is the only place that 431 would apply. So what it also does, and the inverse of when people talk about, you know, people will fight over which night they have their children just to maintain some kind of equal parenting plan. The inverse of this is that 431 will actually promote further lack of income by the lower earner because they need to keep their income below, below 40%. If they go above 40%, 41%, then the split will happen. So this causes this great scenario that we're suffering now, as Silva clearly establishes and can't be debated, that the lower earner receives all the funds. That's what's so important about this. The lower earner receives all the funds. The higher earner is left with nothing. And this is all because of the statement in the current law that says equal or approximately equal parenting time is not grounds for a deviation. So just to get through this a little further and to talk about some of the points that are so important to this, what was mentioned by Honey Hastings and the person who had just spoke, that this is what's going to happen is the higher earner will be left with inadequate funds. What's always referenced is that because if you establish a split of the funds available based on parenting time, that will cause some kind of fight over nights, or that people will try and maintain leverage over the lower earner by saying, I want 50% of the time. What is established when you go, because I've been through it and I deal with this every day, and I've had a parenting plan established. The parenting plan is always established before child support guidelines. That means the parenting plan is put into place, it's established, then afterwards, not based on the parenting plan, the child support guidelines are calculated. Currently, if I had them 100% of the time, and I make $1 more than the other party, the lower earner, I pay the full amount to them. In my case in particular, I do have them the majority of the time. I have them more than 60% of the time, where the other lower earner does not have to pay anything unless she chooses to, because all those funds she has. So just something that's important to this as well, that 1647 addresses a lot of this. I think that there's some contention towards it because of that, that parenting time dictates the amount paid. That is not an issue. It's not part of it. What both bills try to do is address that if there's equal parenting time, there's equal funds available. Currently, per Silva v. Silva, what 431 would do, except for that small 10% window, and that's not even very easy to follow, 431 Silva v. Silva would maintain that all funds go to the lower earner. In my case, it leaves me with insufficient funds to be able to care for my children. It leaves all the decisions for their well-being with that of the lower earner. So I think it's very important, and I would hope out of this, I think it said it more eloquently in what I wrote, but I would believe there's some means of bringing some of the language together. I don't know how the process works in bringing the legislative bill, which is 1647, and the Senate bill, 431, together, but there's important parts to both of them, but neither of them, as it stands, do, especially 431, do anything to help New Hampshire children. And I live this every day. I am not anything but a biased parent who's trying to do the right thing for their children. I think a lot of the studies and discussions that went on, and I did reach out to some of the stakeholders and parties that are here today that were part of creating 431, including the NHLA. I reached out to all of them. I asked to participate in the language. I asked and I got minimal response. And then without any input from actual parents, 431 was created. Not any input from someone like me or a parent that was in support of it. It was done by statistics, by studies, not reality. And I think those things are important. The numbers are very important. It has to meet the criteria that I think even Honey Hastings mentioned, the best interest of the children, which 431 is not, because clearly what I've shown, only that 10% window barely could suffice to have this fund split. And it has to be understandable. If you look at that and you do the math, and I give you the examples, it is without question, it's incontestable that all the funds go to one parent. And this is something I'd be very much part of the discussion. I'd like to answer any questions if anyone has some.
Thank you very much for your testimony. Are there any questions from the committee? Okay. Seeing none, thank you very much for your testimony.
Thank you.
The chair will call Jay Markle.
Just have some handouts for the committee.
Yes, please hand them to Ms. Horgan.
Thank you. I'm just look. Oh, okay, that's over here.
Jenny?
No, Jenny, can you do it? Oh, I'm sorry. Okay. First, I would like to thank the committee for allowing me to address it on this bill. My name is Jay Markell. I'm a practicing attorney in New Hampshire and Massachusetts. A very large focus on what I do is family law. I've also been involved in drafting various legislation in the past, 5-6 years, I would say. As a threshold matter, I'm just looking at some of the terms here, and I've done some homework on it. First, let's deal with some of the opening points of this bill. What has been referred to as net the difference is not actually called a net the difference. According to my reference to this is Child Support Guidelines and Interpretation by Laura Morgan. This is the second edition. It's the most current. And she is one of the leading authorities on child support in the United States. It's actually called a child support offset. And the formula of parent A pays parent B, and then calculate as parent B pays parent A has been well understood and has been around for a number of years. It's actually called the child support offset, as I said, and right now it exists as an offset formula in 32 states as a custodial formula, and it exists presently as a deviation factor in 4 states. And by the way, New Hampshire is one of them. So this was before this bill was done. So it was being done more or less informally prior to Silva, and it had pretty wide acceptance. A couple of other things that some of the problems that I see with this bill is that I think that when I read it, pro se's are going to have a very hard time understanding it, number one. Number two, and most importantly, you really can't, you've heard the expression, you can't tell the players without a program. And if you've heard that one, then one of the things that you have to consider before you even get to a 60% disparity or anything like that is parties have to look at the court considers child support affidavits when it looks at everything, okay? And an experienced judge can do this in probably 5 or 10 minutes. So you really cannot say that a 60% arbitrary guideline or more, 61%, is going to trigger a full guidelines order. So in my experience, what most courts do when they determine this is first of all, it's a threshold question. Has anybody here seen a financial affidavit that the family division uses? Mm-hmm. Okay, so then if that's the case, then you'll go to page 3 and you will look at the basic monthly expenses, okay, that parties fill out. It's a monthly statement. And they're going to look at key expenses, rent, mortgage payments, they're going to look at daycare, they're going to look at school supplies, they're going to look at vehicles and the things that reflect overall lifestyle, okay? So to cut this in stone would be without looking at a financial affidavit. You may well be painting yourself into a corner. Now, for example, states like Alabama, for example, have essentially given up on this kind of thing. And they say that child support is really going to be an individuated consideration. And these are not my words. These are coming from well-established case law across the United States. So shared residential is already treated that way. In reference to House Bill 228, which I heard it referenced before, it is fair and it's very simple. All you do is calculate A versus B, and the court can simply use the rest of the statute to make the modifications as the best interest of the children or justice requires. Okay? You don't have to go through this entire exercise. Now, addressing the bill itself. Okay, I see the following issues. Okay, first, I don't see for low income and gross income from RSA 458C24 why, when the statute itself defines income as income from government programs, why that would not be automatically included as an adjustment to income. I'll show you what I mean. If you take a look at the child support worksheets you have there in front of you, you'll see that absent from it, it's just income, and you'll see that absent from it is any real reference to most government programs. And right now, things like child support credits and so forth are very popular. People are getting them all the time. Those familiar with the those familiar with the current child care credits should be aware that if you're getting 5 years young, children of 5 years young and less, I'll be quick. Oh, okay. Okay, child under 5 years, you get a $3,600 child care credit paid directly to you. Children over the age of 6 up to 17, you get a $3,000 per month, okay, child care credit, and that's paid directly to you right now. Should be included, it's not here. The other thing you can do is that you, by the way, to make sure that parties maximize that, is that you can structure parenting plans where each party gets 182.5 days and both parents qualify, okay? Because they'll have the child in both of their hands. But more importantly, let's look at the practical effects of some of this, okay? If you look at Section 3, basically, it micromanages on this bill. It basically micromanages to a very, very high level. What I'm talking about here see if I can get it out. Okay. You know, basically, if you're looking about, this is a level not seen in New Hampshire. If you look at Section 3 on this bill, I think you'll find that it really goes pretty high. You know, when you're looking at things like adequacy of housing accommodations, nutrition, transportation, and technology, availability of education and educational materials, extracurricular activity, travels, and entertainment. I mean, what you're really doing is inviting a lot of floodgate litigation. If you look at the number of pro se's who are going to come in, and when you talk about entertainment, I can easily see people warring on this kind of stuff. And I can easily see somebody presenting a receipt for a movie theater. And I can see that all of a sudden, the fights will be back and forth. You know Johnny is 5 years old. He can't eat a large box of popcorn, okay? And I can see this being a floodgate, an opportunity to create a lot of real problems. I don't know that the judiciary is interested in micromanaging cases to this level. Also, when you look at new housing, buying food, buying cars, buying computers for people, what you're actually doing is crossing over. You're crossing the line now from child support into parenting plan joint decision-making. For example, parents can have a disagreement on whether their teenager should be driving. And one parent thinks they should, and the other parent doesn't think that they're responsible enough to drive. Now, under this statute, okay, you are now removing joint decision-making under the guise of child support, okay? And what you're doing is you're invading a parenting plan. Because remember this, you go to court and you say, one party says, I want Johnny to have a driver's license, and my ex doesn't agree, okay? Your Honor, I don't think Johnny is mature enough to be driving a car, okay? Well, who's going to get a driver's license on that? Now you cross well into, now you're taking child support beyond the reach of its intent, okay? And what you're doing is you're going to now have courts interfering in joint decision-making, okay? Car insurance. Even worse is car insurance. You have a parent, okay, who is now compelled to buy car insurance, okay, for a child who he or she does not think should be driving. Okay, that child gets into an at-fault accident, and the parent who had the insurance is tagged because he either owned the car or was compelled to buy insurance for a child that he or she didn't think should be driving a car. What's the recourse? None. So in other words, when you look at these kinds of things, you're looking for nothing but problems. Section 4 talks about schooling. So is the remedy for a school which is substandard actually meaning that you should get a full child support guidelines order because the school is substandard? Or does it mean we ought to look at shifting the child into another school if the school is really that bad? Why would a child support guideline order say that if you can do this, then you trigger a full guidelines order? Once again, you're crossing the line into joint decision-making, and you're basically making something like this punitive, okay? Daycare costs, if you please take a look at your child support worksheets, okay? Daycare costs in New Hampshire are already an adjustment to income above the line. When you look at the child support worksheets that you have there, okay, you're going to see that there are really two sections. There's the gross income, and then when you get below it, you see the allowable deductions. Okay, one of them include daycare costs and how that is shared. So why would you have this redundancy built into a, why would you have somebody pay double or triple daycare costs, okay, when you've already factored it into the child support calculation in the first place? You know, so then you would be looking at not shared residential responsibility. You'd be looking at more like a modification for child support, okay? And once again, this bill crosses way too many lines, okay? It steps into parenting plans, interferes with joint decision-making, okay, and micromanages cases to a level I don't think New Hampshire would find acceptable. And then finally, I agree with the bill that it doesn't change, it doesn't constitute a modification, because when you look at modifications on child support, that's only for a material change in circumstances, okay? Not a change in statute. Okay, so that is kind of redundant, but I'd be happy to entertain any questions.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Senator French.
Thank you, Madam Chair, and thank you for explaining this to me a little bit closer. Could you tell me, in Section 3, line 14 in the bill?
Okay.
So when setting child support numbers, when the courts do that, will these nutrition, transportation, technology, would that be something that would, in education, that would fluctuate during the course of child support?
It could, but then once again, it could, certainly, for example, but that would probably be driven by a different set of circumstances. So, for example, in my opinion, okay, so in other words, you might have a situation where somebody loses their job, okay, for whatever reason, or can't provide for themselves, and all of a sudden faces an eviction notice or a foreclosure. But micromanaging, so what does this, going beyond your answer, sir, if I may?
Yeah,
Okay.
go.
Okay. Adequacy of housing accommodations, nutrition, transportation, or technology. I can easily see a pro se going to court and say, I want him to buy me an apartment. I want her to pay for a condominium. I want him, her, whoever, to buy a new car. I want him, they have the money in the bank, and I want that. And the court's going to be tearing his hair out.
So, follow up? So I have a little experience with paying child support. I paid it for 28 years before I was done. It was kind of interesting. I had some very good former partners who we shared these responsibilities, and they weren't up to the courts to decide. I didn't know this had changed so much, and this was about to change it even more. So I appreciate your testimony today to bring that to light to me.
Thank you. I appreciate it, sir. The, you know, the situation is, like I said, it's well accepted. And this is far more complicated a bill than it needs to be. Okay, it's attempting to micromanage things to a level I don't think New Hampshire Judiciary or New Hampshire citizens would be comfortable with. I think it's going to be floodgate legislation. People are going to come in and show somebody who's boss, and they're going to be presenting movie tickets. And I don't know this court, I don't know our courts should be in that business.
Thank you. Are there any further questions? Okay, seeing none, thank you very much for your testimony.
Thank you. I appreciate it.
The chair will call Vivian Gerard. Good afternoon.
Good afternoon.
Do you have copies of that for everybody?
Oh, yes, I do. Oh, there.
Yeah.
This is the two-part. So, oh, wait. Thank you. Good afternoon, Madam Chair and members of the Senate.
My name is Vivian Gerard, and I disagree with this bill. It actually undercuts my case, and I am the Silva v. Silva case, which this law was created as a new child support guideline. This is not a good idea to pass SB 431 FN. Who gets paid off of this if this bill gets passed? Is it because you get more of the Title IV federal funds from the feds and then sends it straight to the state's general fund? You know, maybe you should once, maybe just once, actually care about the children instead of your precious federal funding for money that's not even for the children. Look, guys, you're making this way harder than it needs to be. Is it deliberate? What's your intent in trying to pass this bill? Just give it to us straight up. Give us a calculator based on math so that we can understand it. I mean, look at House Bill 1647. It does just that. Anybody can read it, they can do the math, and you know what the obligation is supposed to be. I support that bill. But you guys seem that you want judges to continue to make it up on the fly with whatever they feel like. Excuse me, but this is just basic math. You know what happens when you give judges that kind of discretion you're suggesting? This right here. See this binder that I brought in? This is what happens when you give a judge too much discretion. This was from my case, August 9th of last year, to fix all the discretions that Judge Julie Intercasso had put on my case. She made up her own discretions, which in fact hurt me tremendously. So yeah, it's me, the Silva v. Silva case. So I separated in December 2014 and divorced in 2016. My ex and I, we actually had the family court judge that stated that my family-owned business, which opened up prior to the divorce and the separation in August 2014, constituted voluntary underemployment. So this business covers all my costs just as we planned. I pay my taxes, so I don't understand why the judge made this discretion on my case. My case has been 7-year sentence. I had over 20 trial court hearings, 4 appeals to the Supreme Court. 2 of these appeals were combined. I had 3 bad judges. The courts just could not get my case right. I was successful at the Supreme Court on my appeals, and the case was remanded back to the family division judge, who chose not to comply with the Supreme Court decision based on RSA 458. In my case, the family division judge had far too much discretion. She assigned 2 downward deviations on my child support to eliminate my state of New Hampshire child support based on RSA 458. It was unclear on the rules and why she deviated from that. Deviations are very damaging to families. This is a huge, huge mistake for the New Hampshire to pass this bill. This law should actually mimic the Mass law given full support at the time of the separation. We all have fixed costs. I'm in the family home to keep the kids in the school system. I actually have a family-owned business operated out of our family home. So there was no way I could just pick up and leave because that would put me unemployed. So I have a mortgage, utilities, and these things don't go down based on a 50-50 parenting plan. Allowing this bill to be passed is not the way to achieve what you wanted to achieve. We need to do a court study. We need a calculator. Math does not jive with the algorithm. The numbers are off. We need to secure the families financially and eliminate this court drama. The family court should decide the cases properly, timely, and within the law the first time. I'm 7 years too late. I'm still in the court system. I still don't have all my child support orders in line. I don't have any order on my arrearages. It's been 7 years. This is not just a case or a study or a game. This is my life. These judges, they decided my destiny. It does affect my children. I should have a way. I shouldn't have to prove why my ex should be paying child support and financially supporting my children. I wasn't going to do this, but after hearing the previous testimonies, I want to give you a little bit of background of what I had to deal with. My ex brought my children into this world with me. It's his responsibility as well as mine to support them. As a family, I put him through engineering school, so he earned a higher income for our family. Now he's making $150,000 a year, plus bonuses. I have his pay stub I can show you. So if you want copies of this book, I'd be happy to get it to you. So I could be a stay-at-home mom for my children. My children, I have 2 girls. One's 13, one's 15. My 15-year-old has a disability, and that's why we chose to have an at-home business so I could work while the children went to school. I also had aging parents. So my parents are elderly, and we brought my elderly parents into my home in order for me to care for them. And I knew that I was going to have high-need children as well. So we decided this 7 years ago. I lost my dad 3 years ago, and my goal is still the same. I'm still caring for my children. I'm still being that caregiver for my mother. I'm still running my business, and I'm dealing with this 7 years later. So that being said, he told me at the time that we could afford it for me to jeopardize my employment. I compromised my employment. I jeopardized all my skills in the workplace for my children. He supported me back then. And again, I didn't even get alimony in my case. They told me I was underemployed. So my children had to sacrifice the traditional and normal activities their friends enjoyed, such as vacations, day trips. My daughters like to do ninja gym, gymnastics, which other children had taken this for granted. This does interfere with my joint decision-making with him. He can go do all these activities. He can pay for all these things. And while I was going through all this, my ex's court financial affidavit, again, showed $150,000. And granted, I only made $50, being a stay-at-home mom. So our income levels are not the same. And I respect that, you know, everybody has their situations, but he supported, at the time, me putting my career on hold for our family. I lost 15 years of my business skills trying to accommodate my family's needs. While he enjoyed vacations to Puerto Rico, to Paris, to the Grand Canyon, and recently purchased a Porsche Cayenne, in addition to his Italian motorcycle, a 25-foot ski boat, all while having child support arrears that were in excess of $44,000. This was as of last year when Intercasa was still on the bench. He was never held in contempt, and it appears that there's no consequences for the contempt due to this judge's discretion in my case. Again, this book here shows all the discretions that I've been battling on my case. So how is this equal or close to equal parenting lifestyles if he's traveling all over the place and I am just trying to pay my mortgage, pay my utilities? I'm missing out on taking my kids on vacation, fun activities, buying expensive gifts just like he does. He buys cell phones, he buys iPad minis. He can do these things. And this past weekend, he brought my daughter to Starship in Texas because he is trying to win them over so he doesn't have to pay child support. He is trying to get her so far over by buying her and using her as a pawn to avoid child support. And that to me is not fair. It's just very damaging to my relationship with my children. And a lot of these things that you guys decide on, you guys might not be in the situation of living this every single day. Let me tell you, I live everything every single day that jeopardizes my relationship with my children. And yes, this causes a strain on my finances and my children. He tells the kids he's been paying full child support for 7 years. And we all know that's a lie. My relationship with my children has been damaged because of child support, because of these activities. And my relationship with my children will never be the same. They don't believe me because, unfortunately, he's been telling the children otherwise. When you're supposed to leave the children out of it, he still has been telling them. He's constantly not following court order. And even on child support, when he was ordered just in October, I can tell you right now, I got a child support check for $533 when he was supposed to be spending $1820 every single month. He chooses what he wants and when to pay it and how he pays it. Here we are, we were supposed to go today, but I needed to be here to testify. So I asked for a continuation on my court appearance today because this jeopardizes me. It jeopardizes my children. And unfortunately, now that my children are 13 and 15, I try to give them little pieces of it to show that I am not lying to my children. I told my children I'm coming here today to stand up for what I believe in. And I believe that teaching my children to be strong, independent businesswomen is in having a voice here today. I hope that later on my children don't have to do what I'm having to do. And all of you here today, you guys might be going through this with your own children, with your grandchildren. And unfortunately, you're not going to know the impact that it has had on my life and my children's life. So once again, this is my life, and these judges held my life in their hands. They determined and dictated the destiny of my life. So I am here supporting Bill 1647, and I am opposing this Bill 431 for these reasons. So if you have any questions about the facts on my case, I'd be happy to answer them, and thank you for listening to me.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Seeing none, thank you very much for your testimony.
Thank you.
Are there any other members of the public who would like to speak to Senate Bill 431? Okay, seeing none, we'll close the public hearing. The committee will be in recess for 5 minutes.
See what you stirred up?
Okay. The committee will come out of recess, and the chair will open the public hearing on Senate Bill 294 and recognize the prime sponsor, Senator Bradley. Good afternoon, Senator, and thank you for waiting.
No worries.
Good afternoon, members of the committee. For the record, Jeb Bradley from Wolfboro, Senate District 3. I think all of you are going to be pretty familiar with this bill. It is the Senate passed version of Senate Bill 92, not the introduced version, but the Senate passed version minus 2 sections. The first section of Senate Bill 92 dealing with criminal mischief has been deleted at the request of the folks that asked me to sponsor it, as to was Section 3 dealing with the Police Standards and Training Council. So what you have in front of you is the balance of Senate Bill 92 in Senate Bill 294. I've refiled it because a lot of work was done on this bill, both in this committee and in the House. And it got to the House, and a lot of work was done on it in the House, thought there was an agreement, and it got tabled. So, since this issue, at least in my humble opinion, is one of the most important issues of how we provide for safety in our state, I think we need to take another look at some of the bail issues that were triggered by Senator Feltz's bill a couple of years ago, which I think, Madam Chair, both you and I sponsored, but I think we've learned that there are some provisions that should be changed. Bail should be available to people regardless of income, but at the same time, what we've seen in New Hampshire and across the country are people that are abusing the system and are not showing up for court appearances, or people that have committed violent crimes getting released immediately and reoffending almost immediately. There was a notable case in Wisconsin just a couple of weeks ago, and I'm not implying that that has happened in New Hampshire, because it hasn't, where the car created the death of 5 people, as some people would have indicated. But that was somebody with a long list of offenses that should not have entitled him to bail. We don't want that to be what's happening in New Hampshire. So I have resubmitted it with the hope that a second chance will be a good thing for this bill. So if you look at the bill, just to go through it quickly, there are 13 enumerated crimes under statute, starting on line 25, homicide, first-degree assault, second-degree assault, domestic violence, aggravated felonious sexual assault, kidnapping, stalking, trafficking, robbery, possession of child sexual abuse images, computer pornography, and felonious use of a firearm. Those 13 crimes would create a rebuttable presumption that the person is a danger to the public. And in order to receive bail, that person would have to go before a judge. Pretty simple. It's not an automatic turnstile, nor should it be. And I think we've seen instances of that in New Hampshire. The second part of the bill is something I worked on with Senator French, in particular in this committee last year, was on not appearing at court appearances. And we made changes of that to, make it, I think, more acceptable to Senator French. They're reflected in that if you have 3 court appearances that you miss within a period of 3 years, that that person shall be detained in pre-trial detention. I think that makes sense too. So that's the nuts and bolts of the bill. I think there are a couple of police chiefs here that will testify, but I think one example to me sums it up, and it was testimony that this committee received last year from the chief of police in Nashua, who was served as a law enforcement officer for 27 years, and he testified in support of Senate Bill 92. And what he talked about was a case in December 2020 that the police department of Nashua received a call for a domestic assault that was in progress. A suspect had gone to the victim's house with a firearm. Upon arrival, the suspect had forced entry into the house and assaulted the young woman. The suspect was subsequently arrested. The firearm was retained as evidence. The police officers assisted the victim, and as part of the victim assistance, they conducted a lethality assessment protocol on the victim, and she checked off, as the police chief said, every box, meaning she was at the highest risk of danger from the suspect. However, when the suspect got to booking, the police officers attempted 3 times to convince the bail commissioner the suspect was high risk and needed to be retained. 3 times, explaining what had just happened. But it didn't matter. He was released on $200 bail. That night, he returned to the victim's house shortly after being released and proceeded again to force his way in, beat the victim, and rape the victim throughout the night. This is what we're trying to prevent. This is why Senate Bill 92 and now the offshoot of Senate Bill 92, 294 is so important. I believe New Hampshire is a state that cares about victims and protects victims from violent crime. And this is a small step, I think, in fixing some of the issues that have arisen as a result of the bail reform efforts of several years ago. Small, but absolutely necessary if we're going to ensure safety in New Hampshire. So thank you, Madam Chair.
Thank you very much for your testimony, Senator. Are there any questions from the committee? Senator French, then Senator Whitley.
Thank you, Madam Chair. Thank you, Senator. In that case you just cited, what in our current law made that bail commissioner think that that actor wasn't a danger? That is the question of the day. But my understanding is, and there's a whole long list of examples such as that I introduced into the record, and I think other chiefs introduced cases into the record last year of people that have gotten bail like that. You and I would think common sense. Why would you ever release somebody like that? Right, because. But according to, you know, the police chiefs that try to enforce our law, and they're here to testify, the way that the law was constructed, whether intentionally or unintentionally, has tied the hands of the bail commissioners, and they release people. And that's why I think we need to change the law and fix it so that for the crimes that I enumerated and are, you know, starting on line 25 of Senate Bill 294, outlined exactly what those crimes are. So, thank you. Thank you, Madam Chair. So, not to put you on the spot, because if you don't know, you don't know, but do you know what specifically in the laws we have on the books prevented them from detaining that individual? I think it was an interpretation of the law that we passed several years ago that said people are, even for these violent crimes, not to be held. So, again, I think, you know, we have a couple of chiefs here, I believe one from Bedford and one from Hollis. They can certainly answer that question. Great, thanks. Thanks.
Senator Whitley?
Thank you, Madam Chair, and thank you for taking my question. Certainly I would agree with you that, protecting victims is really such an important thing that we need to do, and something, of course, that I think about deeply as a woman and as a mom. So, but of course we have to balance other interests here. And I think, when I was considering this bill last year, the stories are horrific, right? It's just, they're hard to listen to. And what I also wanted to hear was some more actual data collection. So I know that, many people, including lots of people in this room, worked on this bail reform for a long time. There was a lot of, lots of work gone into it over many, many years. And so I just feel like, would you agree that maybe adding some more robust data collection is really necessary before we sort of really shift the paradigm here?
Well, I disagree with the assumption that we're shifting the paradigm. We're not shifting the paradigm. We're ensuring that people that commit the kind of crime I just outlined, which is not a victimless crime, which has a victim who was raped and had somebody that broke into her apartment with a firearm, arrested with a firearm, then was bailed, and then went back and raped her, that doesn't happen again. That's not shifting any paradigm.
Follow up?
Yes, follow up?
Well, but it is true that we're going to have people that are going to be detained maybe for 72 hours, right, without a bail hearing, right? So we're going to do that, and we're going to do that without consideration of whether they're going to lose their housing. We're going to do that without consideration of whether they have childcare. We're going to do that without consideration of whether they're going to lose their job. So to me, that's a paradigm shift.
Well, and we're going to do it under the scenario you outlined, and sorry to interrupt, without consideration of the potential for reoffense and somebody being, violently attacked. We can just be very thankful that, to the best of my knowledge, no murder has occurred. But what does it take to stop that? And we've seen in other states where this leads. And I think we should, for the 13 crimes outlined that I think, Senator, you and I would agree are pretty heinous crimes, starting with murder and assault and felonious assault and domestic violence and pornography, et cetera, there should be a rebuttable presumption.
So I didn't quite get to my question. Well, I didn't get to my question. So where I was going is that when this exact bill was over in the House, we heard from the court system that this was going to result in a $3 million potential hit to the state for more people in our jails and prisons. And so, I'm sort of curious why there's not a fiscal note attached to this if we know that that's going to be the cost here.
I think there was testimony from the judicial branch. I'm surprised that the fiscal note has been, as indeterminate as it is, but at the same time, what price do we put on safety? It is one of the core functions of what makes a civil society civil.
Yeah, follow up? Yep, and so, and I would agree with that, and I think that we talk a lot about that in this committee, and, as all the committee members know, I care deeply about safety of my community and of my family. But I think, these considerations are incredibly important. And I think, when we're trying to make these balance of interest, don't you think that we already have a mechanism in place to balance those interests? The way that I read the statute and the way that I think that Senator French was getting at it, we have a mechanism here, but perhaps would you agree that we just need some education about interpretation of the current law?
Senator, I'm trying to remember when Senator Phelps' bill passed. I think it was in the 2018 session, I believe. May have been 19. So I think we have plenty of evidence that we've had problems. Thank God we haven't had more problems similar to what other states have had, where there have been countless problems. It's bad enough in New Hampshire, and I think time to understand that it needs to be fixed, or else it's just a matter of time before the problems in New Hampshire multiply more than they already have.
Last question?
Follow up?
Thank you. And so my sort of thinking about the sort of data trend and what you're mentioning about, we want to prevent something in New Hampshire. So, certainly we want to look at those trends both in New Hampshire and around the country. And my understanding is that crime has actually gone down in New Hampshire, particularly with violent crime, in this time that bail reform has passed. And so it says to me that, what we're doing is not perfect. We need some more information. We may need, the solution may be more education about how to better interpret, work with our bail commissioners, work with our prosecutors, work with folks to make sure that what we have is actually implemented. We have crime that's decreasing. I don't see an increase. What would see a necessary changes if we saw an increase of these crimes, where we're not seeing that? Are you seeing something different?
Well, this is the argument that you're taking the side that I took on the floor a couple of weeks ago when we talked about a Second Amendment bill. Yes, we're among the safest states in the nation, and that's a good thing. I think we're the third safest state in the nation, but there are a lot of other things that we've done right that I think have created that. We haven't defunded our police. We support the men and women who wear the uniform as well we should. We allow people to defend themselves, and I think that has helped significantly counter the types of situations that we've seen in other states. So let's not make the mistake that other states have made and say, okay, bail reform's working, when we know it's not working, and we have examples of it not working. And so for those crimes, I'm not talking about, simple crimes that are victimless. These, I think you and I would both agree, these are crimes with real victims. And we should be on the side of victims, I believe. Now, you and I may see it different, and we'll continue this debate, but that's where I come down.
Right, and my last follow-up is I think we are on the same side of protecting victims. I don't think we are on the same side that this is the right solution at the right time.
Are there any further questions for Senator Bradley? Okay. Seeing none, thank you very much, Senator.
Thank you.
The chair will call Marianne Dempsey.
Chair, Senators, thank you for the time today. The judicial branch, sorry for the record, Marianne Dempsey, General Counsel for the judicial branch. I believe as Senator Whitley mentioned, when this was Senate Bill 92, the judicial branch did submit a fiscal note. I have a copy provided to the senators. My main purpose today is for the committee.
Thank you very much for your testimony. Senator Gannon has a question.
Just a quick question, Marianne. Thanks for coming.
I'm sorry, I always assume it's on, I apologize. Sorry, thank you, Senator.
Thanks for coming today. We heard the approximation $3 million for 3,000 or so bail hearings. What would the cost of one murder hearing be? Trial, full trial?
I don't know the answer to that, Senator, but I can get you follow-up information, because obviously that's an extensive case. The 3,000 that I'm speaking of are the 2 misdemeanor cases, the 2 misdemeanor charges. They're not a murder charge. So what I'm saying is of the 13 offenses, 2 could be charged as misdemeanors, and those are would result in the 3,000 hearings.
I understood what you were saying. I was saying compared to the result, what's going to happen soon down the road. The cost for murder trial would be millions and millions plus the loss of a life.
I'm
Thank you.
happy to follow up and to get the court, the committee that data.
Thank you.
Are there any further questions? Okay, seeing none, thank you very much.
Thank you.
The chair will call Frank Canack. Looks like.
Madam Chair, members of the committee, thank you for the opportunity to testify today. My name is Frank Canack. I'm the Policy Director with the ACLU of New Hampshire. Before I get started with my testimony, Senator French, just to follow up on your question earlier, let me just make sure I have this in the right spot. So in section 597(2)(3)A, it says, this is regarding the standard for detaining someone pretrial, and this is for any offense. So it used to be certain offenses you couldn't be held, now it's all offenses you can be held. Quote, a person charged with any criminal offense, and then ... can be held, the court may order preventive detention without bail or other means, least restrictive means, or electronic monitoring, if the court determines by, quote, clear and convincing evidence that the release will endanger the safety of that person or the public. And so current law right now, all of the horror stories that we've heard, which are in fact horror stories, there is a mechanism in place to ensure that those folks can be held pretrial. They just have to make their case, and it's a lower standard. It's only clear and convincing evidence. It's not beyond a reasonable doubt. And so when we're talking about taking someone's liberty, I mean, we're concerned if it's not a higher standard. This is a lower standard in place right now under current law. And so, I guess we can look at this bill a couple of different ways. One is, kind of the theory and practice of this bill. And so, at the theoretical level, and I know that we're talking about real people, so I don't want to stay there too long. This bill flips the fundamental presumption of innocent until proven guilty on its head. For 13 offenses, it would mandate the incarceration of people based off of any one of those offenses, based only on unsubstantiated allegations. And then they would have to hold 72 hours and then go before a judge. This bill also, there is no data to support this bill. So as Senator Whitley noted earlier, right now in New Hampshire, when bail reform went into effect in 2018, crime stats for Group A crimes in New Hampshire have decreased 14%. And so if there was really a problem here, the data does not support that. And again, we're not seeing any data from those attempting to undo this reform that has reduced the number of people held pretrial in New Hampshire since it went into effect. In addition, as we've heard, and I think we need to get some clarity because of some things we've read versus what was just presented in the fiscal note, it's at least a couple of $1 million a year in additional costs that we're talking about. And so I think, fundamentally what we're talking about is this legislation does not necessarily make communities safer. There is a mechanism in place under current law to hold people if they're a danger to their community or a flight risk. In addition, we often hear from proponents of this legislation that we're really talking about violent offenders, when in fact, if you read the legislation, the first part, the 13 offenses, deal with violent offenses. There are numerous other sections of this bill that deal with nonviolent offenses, including the ability to hold people pretrial for Class B misdemeanors, an offense that if you're convicted, can't even carry jail time. And so that is deeply troubling to us that we have a bill that would enable that broad of a sweep and undo the reforms that we've seen. In addition, some of this around the ability to hold people is around FTAs. And so again, the Rockefeller Center at Dartmouth did a study on bail in New Hampshire a couple of years back, and what they found is the same as in most states when we're talking about FTAs, that the majority of people are not coming to court not because they're trying to run, but because of childcare, transportation, employment requirements, and they simply forgot. And there are data-driven, proven solutions to reducing the likelihood of people experiencing an FTA, including text messaging, things that are safer, that reduce the number of people in our prisons, that keep people with their families and in their communities, and actually affect, are a solution to the underlying issue, which is making sure that people are showing up for court. And so from our perspective, this bill needs a lot. This bill is, it's unnecessary. We have no data to support the need for this bill. Crime is down. The costs are extreme. There are other proven ways to handle these situations. And again, this is not about violence. This is about all crime. So thank you very much for your time. Happy to answer any questions.
Thank you very much for your testimony. Are there any questions? Okay, Senator French, then Senator Gannon.
Thank you, Madam Chair. Thank you for your testimony today, Frank. Could you tell me which of these charges are Class B misdemeanors that are listed here?
Definitely. Let me pull the bill real quick. So it's in a couple of spots. So in section, let's see, C, in section, so we're talking section 3C. This is for people who are out while on release, and if they commit a driving or operating under the influence, that's a D. In addition, and the broader swath of this that we're deeply concerned with is section 8. And so this changes a very important may to shall. And so this says, quote, a person charged with an offense who is, or at the time the offense was committed, on release pending trial for any felony or misdemeanor under federal or state law. So misdemeanors, marijuana possession could be a misdemeanor under certain circumstances, can be held pre-trial if they commit if they are rearrested while on release. And so, again, a whole class of B misdemeanors in there, A misdemeanors. Okay. Again, not violent. We're talking a whole swath of crimes there.
Great, thank you.
Mm-hmm.
Senator Gannon?
Thanks. Just tell me a little bit, Attorney Knapp. Why do you consider it unsubstantiated at this hearing if they have to have a clear and convincing, I know not beyond a reasonable doubt? Why is that seems like a fairly high burden at such an early point when I haven't really got to see that much of the evidence or determine a course of action. Why is that such a low standard to you and such a high standard to me?
That is a low standard because in our criminal system, it's beyond a reasonable doubt. And so when you're taking someone's liberty...
That would be for conviction, right?
Yes, I'm talking about for conviction. And so
but we're not at that point at all.
No, but you're talking about taking someone's liberty at that point. And so we think there should be at least some standard there that ensures that folks are not being held.
We're just happy with a different standard.
Yeah.
Thank you.
Are there any further questions? Senator Khan.
So are there any of the offenses that were identified previously that you believe ought to be separated from detention?
From our perspective, we have a system in place that ensures, so our concern is that categorizing people, we all know that in New Hampshire, charges are brought, they're sometimes later, or people are arrested and they're brought, when a prosecutor gets the case file, they very often may change the charge when they actually read the case file. And so having this, broad swath of offenses where you are mandatorily held based off of just a categorization of offense versus an individualized determination, that's where our concern is. And we feel that current law provides that individualized determination and that we give the courts broad discretion on very important matters across the board. And this is no different, and we should rely on the courts to do their job, to use their judgment, and to ensure that our communities stay safe, which they have been.
Can we, if I can continue,
Sure.
Can we meet the caseload to assure safety and still hold the hearings in a timely way?
I'm the wrong person to speak with in terms of caseloads. I would defer to the courts on that, but I do know that we are, there's other legislation that'll be before this body around moving away towards the criminalization of marijuana, for example, that'll drastically reduce caseloads. And so if we're concerned about making our community safer and ensuring that we are using our courts for things that are actually undermining public safety, there are a whole host of things that this legislature could consider short of taking individuals' liberty based off broad categorizations, which is exactly what this bill would do.
Thank you.
Are there any further questions? Senator Whitley.
Thank you, Madam Chair, and thank you for taking my question. So I do remember, maybe it was summer 2020, the Civil Rights Division of the Attorney General's office was sort of asked, what work they're doing to address certain disparities in the state. And the Attorney General's office had mentioned bail reform in particular as something that was really important. So I'm wondering if you had any thoughts about that. Is bail reform pulling this back? Is that taking us backwards in terms of trying to address racial inequities in our prisons?
Oh, absolutely. I mean, if you look across almost any category in New Hampshire's arrest rates, there are broad disparities in arrests. I think the most recent data I saw in marijuana, for example, 4.1 times more likely for black people versus white people. Our incarceration levels in our prisons and our jails are all disproportionately black people. And so anything that we can do to reduce the burden is something I think this legislature should look deeply and care deeply about. I think that's one of the many aspects that trouble us with this bill, in addition to just having these categorizations that run across. And, I think folks, again, as was mentioned earlier, I think Senator Whitley, you mentioned this, the Bail Commission brought together diverse stakeholders, including court system actors, judges, prosecutors, defense counsel, civil rights advocates, law professors, others, to look at this matter. And they came up with reforms. So the 2018 law passed. I think 2019 and 2020 additional reforms were implemented based off of the recommendations of the commission. And here you have something that is completely outside the scope of anything the commission recommended being brought to this legislature at a time when things seem to be working according to almost any other actor in the system.
Thank you.
I just have a quick question. Those statistics that you just quoted, are those for New Hampshire or are those for nationally?
For disparities?
Yes.
Marijuana is New Hampshire specific. That's based off of an ACLU paper that was released about 2 years ago. And I pulled the most recent data a little while ago. I'm really bad at math, so I'm trying to figure out disparities. The disparity is still huge in marijuana arrests. I just don't know the exact percentage. I'm still trying to work that out.
Okay, thank you.
And then the same with across the board with prisons, jails, et cetera. Those are New Hampshire specific. Yeah.
Thank you. Are there any further questions? Senator Gannon.
Those disparities you mentioned, couldn't I, if I use the numbers differently, just show that it's an economic thing, not a racial thing? From what I've seen, the data tends to imply that it's much more economic than it is racial.
So I guess marijuana, I think, is the best example because I think you can do I think for so many offenses, it's difficult to do an apples to apples comparison, but with marijuana, you can because we do know from national data that black people and white people use marijuana at roughly the same rate. And so arrest rates should be similar, and they're never similar. I've worked in multiple states. I grew up in Vermont. I've worked in the South. I've, for many, many years, just came back up north. Disparities are across the board, anywhere I've ever been.
Quick follow-up?
Yes, please.
Would it just be, could it be explained by as simple as more minorities live in the cities, police are in a denser location, and in the suburbs where there's more, you're not as visible to the police. So it wouldn't really be a racial thing. It'd be more of, again, more economic where you live.
So they've actually done some pretty amazing geolocation mapping of arrests. And so this is going outside of New Hampshire here. So in Washington, D.C., for example, I know when they moved towards legalization in D.C., they actually geoplotted all the arrests for marijuana possession. And, you have 15th Street, the east side, the west side of the city. Predominantly at the time, black people are living on the east side. Predominantly at the time, white people are living on the west side. Even near the campuses, GW, American, et cetera, the dots were all over the east side, barely any dots, including in the universities where people are using marijuana.
Thank you.
Definitely.
Okay, are there any further questions? Senator Khan.
Thank you. I'm trying to follow the current statute and what the changes are. I got to say, I'm sympathetic to the offenses that are being changed for the procedure in 3A, 1. But then there's a 2 here, and I'm not sure how to interpret the 2. And I'm looking for your comment on number 2.
Adding the other?
Yes.
So I think what they're doing there is 2 used to be the 1, and so going back to pre-2018, there were certain offenses where you could be held. So fast forward to bail reform, they said, or you could not be held regardless. So fast forward to bail reform, all offenses are now jail, or you can be held pretrial if you meet the threshold by clear and convincing that you pose a danger. And so what this is doing is literally just saying, the previous language was any person charged with any criminal offense, blah, blah, blah. Now they're adding in the section 1 above, and so they have to create the other because they're adding these new offenses that create the new categorization, if that makes sense.
Okay. I'm there. Thanks.
Are there any further questions? Seeing none, thank you very much for your testimony.
Thank you. And can I just note one more issue, if that's okay?
Yes, please.
One other issue, and so I know, again, what I've heard a lot from folks who are bringing this legislation, that this is also not about bringing back the criminalization of poverty. And so again, if you look at SB 294, the core component of ensuring that there is a financial assessment to ensure that you're not jailing people just because they're poor is in, let's see, section B3B4. But then there's a curious strike in section C, 3C, where you look and they actually strike out the financial assessment out of the current law. And so I think what they're trying to do for that one offense, for that one condition, is actually take out the financial analysis and open up the door for people being held pretrial simply because they cannot afford their bail.
Okay, thank you very much.
Thank you.
The chair will call John Bromsky.
Good afternoon, Madam Chair. Pretty decent rendition of the name.
I try sometimes, not always successful.
Thank you, Madam Chair, members of the committee. You have my written testimony that was emailed to the committee members earlier today, and it's being passed around in written form. And I'll be brief. I'm not going to read that testimony. You already have it. It's important that, first, that you recognize that the Chiefs of Police Association are strongly, strongly behind this legislation. It is sorely needed change, although strategic and laser focused on certain elements of safety, but it is about, with no doubt, about the safety and the quality of life for you, your family members, and every single Granite Stater in this great state. Yes, we do have low crime in New Hampshire, but we want to keep it that way. And the Chiefs of Police Association and our colleagues in the Sheriff's Departments and the State Police and Department of Safety are concerned about the trend not only in the country, but also here in the state. And as you can see from my written testimony, there is ample evidence of cases in which people have been shot at, they've been stabbed, they have been victims of violent crime, child predation, and these people were released on their own recognizance. In no world does that make any sense for the quality of life here in the Granite State, or your safety, or in the safety of your family. This is not about money. This is about the safety. This is the representation, I hope to be the embodiment of the representation not only of the chiefs of police for the great state of New Hampshire, but also the people that we never hear from, the victims of crime, the people that our officers, our detectives, the troopers and sheriffs have to go to at domestic violence situations where a partner was shot at with children in the house and the person was arrested and then released. That has to stop. There will be additional tragedies, more so than the one that Senator Bradley so aptly recounted for you that occurred in the city of New Hampshire. This is about the quality of life. This is about safety. This is not an unconstitutional law. There is nothing unconstitutional about this particular proposed legislation. Everyone, despite what you may have heard, who has been charged with a crime will be afforded bail. everyone will be afforded, let me repeat that, everyone will still be afforded the opportunity for bail. What we are asking for and pleading for, actually, is to make sure that a judge, an independent magistrate, gets to hear an argument from not only the prosecutor but also defense with respect to whether or not a person who has committed the most violent, heinous crimes that could be committed in the granted state should be released out on bail. That's what we're asking for. We're asking for and pleading for people that reoffend over and over and over and over and over again, leaving a wake of victims behind them, that they eventually need to be held pretrial detention until their cases are adjudicated. This is not about money. Yes, it may cost money, but if you would like, you could look at the testimony in the House committee that heard this last session. Representative Abbas, I think, made a very cogent argument with respect to the number of cases that he calculated that judges would hear in the various districts and counties across the state where that previous bill enacted, and he found that it was not an onerous number based on the number of members of the judiciary based on his calculation. So with that, I just want to end by saying that this legislation hopefully will turn off the sign that someone has erected at the border of New Hampshire that says crime does pay. Thank you.
Thank you very much for your testimony this afternoon, Chief. Are there any questions from the committee? Senator French.
Thanks, Madam Chair, and thank you, Chief. On page 1, line 25, it has a list of charges. First-degree assault, second-degree assault, domestic violence, all those murder. I mean, would bail be given to all those people?
Yes.
It would?
Yes, it would. What we're asking for is that a judge makes the determination as to bail, not a bail commissioner. You've heard testimony both from law enforcement in previous sessions that people have been released by bail commissioners. There is no amount of education. There's no amount of data. First, the original bail reform bill wasn't predicated on data. There is no amount of education that's going to help and assist making these decisions. It needs to be in the hands of an independent judge who can hear a cogent argument from both the defense as well as the prosecutor. So yes, they will all be afforded bail.
All of them?
All of them. Just like they are today. Someone who's arrested today under the current law for murder, right? If they've been arrested for murder on probable cause or based on a warrant, they're going to go before a judge and there's going to be a bail hearing.
I'm just trying to get this straight. So there'd be a bail hearing or bail would be set?
There's going to be a bail hearing. Bail may or may not be set.
Okay,
The judge may
so they
decide.
won't all be bailed out?
The judge may decide that there are no conditions that would allow this individual to be released that would ensure the safety of the community.
That seems reasonable to me. But the rest would be just money? It's a difference on how much the bail's going to be?
Of course, I can't speak for what the judges or bail commissioners will do. My sense is that it's pretty clear that with this language that judges will probably still continue to submit individuals to bail, probably based on the same calculation and monetary levels and thresholds that they currently use. I don't see any change in that.
Okay, well, thank you.
You're welcome.
Are there any further questions? Okay. Seeing none, thank you very much for your testimony.
Thank you.
Are there any other members of the public who would like to speak to Senate Bill 294? Okay. Seeing none, we'll close the public hearing. Thank you all for being with us this afternoon.
We gonna exec this today? No. Oh. Just a little Judiciary Committee joke. That's all that was.
So just as that, we should have thousands of people signed up virtually for that. Thousands. To speak? No. Oh, yeah. Well, I can imagine. Yeah, another Sunday. Yes, that's why I was, there's only on that particular